Hey, what's up, guys? You are about to watch an interview that I sat down and did with my good friends and co-hosts, Ash in America, over on my brother from another mother, Alpha Warriors platform. Now, we both, all three of us, felt that this was such an important episode to get spread as far and wide as possible that Alpha gave us permission to release it on our platforms as well. So if you guys did see this on Alpha's platform, it's going to be the same interview. Now, I want to preface this by saying it is a 3.5 hour interview. Throughout this interview, it's about Tina Peters, the Mesa County clerk that was persecuted under the Jenna Griswold and Colorado Department of State out there. She's currently serving 9.5 years. You'll get all these details throughout the stream. But I did something that I haven't seen done anywhere else before. I went through personally and clipped out some of the most important key moments of this trial. Now, this is part one in a part three series of the Tina Peters story. And I also want to point out that the day after me and Alpha and Ash released this over on Alpha's platform, Todd Blanche put out a message about Tina Peters and trying to get her out of federal prison. Now, that is very relevant to what you're going to see in this interview, and perhaps somebody's watching. I don't know. But I do recommend you guys try and watch this whole 3.5 hours. I think it's action-packed. It's a lot of good stuff. The beginning half, Ash is going to kind of lay out the whole story, how it started. And then once we get into the clips, you'll see that from there, it blows the whole narrative out in Colorado wide open. So thank you guys all so much. Please give them both a subscribe over Ash's Ash in America. And I believe her Rumble is Ash for Freedom. So Ash is ashinamerica.substack.com, and you can search on Rumble for Alpha Warrior. I think it's X Alpha Warrior Show X, or just the Alpha Warrior Show. Give them both a subscription, and thank you guys so much. Enjoy the show, and we'll see you next time.
All right, folks, remember, support the people, support this show. All the links down in the description, including the links to tonight's amazing guest faces and voices you'll remember. So without further ado, let me bring on my two co-hosts tonight, Brian Lupo, aka CanCon, Ash in America. Thank you guys both for joining me. I think we can all agree that this is a conversation that needs to be had and information that needs to be heard. So I want to start off, I got the audience pumped up with a monologue, the one that I've worked so tirelessly on. And I was in a space a couple weeks ago, but I've noticed it off and on where people will bring up Tina Peters. And to this day, there are still people that are clueless to who she is or what the story is. And, I was listening from the tunnels while I worked, and then I heard some people go up to try to explain it. But even their explanation of Tina Peters' story and what was going on was not completely accurate and had a lot of gaps. And I was just like, how many more people kind of maybe know this name, but don't really understand what's going on? And it's so important, especially, with our elections, of who Tina Peters is, what her story is, and why she's in prison right now. And so you two are some people that I absolutely respect when it comes to this. So who is Tina Peters?
So, Tina Peters is a Gold Star mother, former Mesa County elected clerk, small business owner, an upstanding citizen. Never had a record of any kind prior to what happened to her in 2021. She was the Mesa County clerk, and the prior election to 2020 had some anomalies in local races. So this would have been, I believe, the 2019 election where they did, local school board stuff and county commissioner stuff. And there were some, concerns and anomalies that were reported, and Tina Peters paid attention to that. And she started to, have contacts and relationships with people in the local community that were concerned about elections. And in, then the 2020 election happened, and everybody was concerned. Everybody with a brain was concerned about what happened in the election. 81 million real lawful American votes, as Chris said, and not being able to ask questions about it. Right? You were not allowed to question Joe Biden getting 81 million votes. And so Tina Peters was serious about election integrity. She took her statutory authority very seriously, and she was, trying to figure out what happened. In 2021, the state of Colorado was doing what was called a trusted build. And the trusted build is essentially updating the golden image on the machines. They go around all the counties, they update the election machines and software. And the allegations and concerns of grassroots activists at the time, and I was focused on other things here in Colorado. I was working with a legislator on potential election integrity legislation at the time. It's back when I was naive and thought the General Assembly in Colorado was going to get anything done. But there were folks that were focused on making sure that the records of the 2020 election were preserved prior to the trusted build, because if you're changing the golden image on a machine, you're ostensibly or potentially wiping the machines. And there was, cyber people were saying, hey, this is problematic. And, HAVA says 22 months, all election records have to be preserved. And Colorado says 24 months. And it's been, 6 months. And they're going in and messing with the machines. And so several clerks in Colorado were looking at how can I make sure that I'm upholding my statutory duty and preserving all of the election records of the 2020 election. And that's kind of the start for what ended up being, the substance. I think where we'll spend most of our time today is the substance of Tina's trial. So they went in. I'll pause there in case anybody has.
I do have a question, actually. Yeah. What was the excuse they provided for doing the rush in 6 months versus the 24 months or 25 months?
They claim it's not a rush. So they say that they have to get the machines ready for the next election, right? So this would have been the 2021 municipal election. And they have to get all of the machines ready. So we have to, and this is like a vendor thing too. It happens all over the country. It's not just in Colorado. They go in and they reset some things and update the machines to prepare them for the next election. They claim, the state and the counties claim that they preserved all of the records that are required to be preserved. And this is a topic that on Why We Vote last week or a couple of weeks ago at the time this airs, Brian and I talked extensively about what records have to be preserved, because the same people that persecuted Tina Peters are still peddling the messages that there's nothing to see when it comes to the trusted build or the Mesa County reports. They're just not elections experts, so they don't understand how things work, but everything is fine. We preserved all of the records that are required to be preserved. Interestingly, they omit operating system logs and other type of system logs from what they are required to preserve. HAVA and the vote, specifically the voluntary voting system guidelines downstream from HAVA, they explicitly mandate the auditable record of the system logs. But the entities like the EAC and the other professional associations have kind of morphed that into, well, there's this set of records that we have to preserve, and that's what's required by law, and we can just wipe everything else and it's fine. And if you don't understand that, you're just not an elections expert. Importantly, that would never work in any other industry for auditability. If you're wiping the system logs and your machines are critical infrastructure to what you're being audited for, somebody's going to prison probably. But in elections, it's just how elections work.
So 52 USC 2071, which is the law that requires that at the federal level, was created in 1960 with the Civil Rights Act. That's where that law originated from. And obviously in 1960, we weren't voting on technological machines for, computer software for our vote. And so the clarity on that is kind of what they're saying in Colorado. The Colorado County clerks just put out, this big report. It's an absolute joke. And Ash and Colonel Smith went through it on Why We Vote last week. The thing is I think it was, and I have it right here if you want to pull it up, it's the Federal Prosecution of Election Offenses 8th edition from 2017. And if you read down there at the bottom in reference to what type of records need to be retained, it says, quote, it provides that, quote, all documents and records that may be relevant to the detection or prosecution of federal civil rights or election crimes must be maintained if the documents or records were generated in connection with an election that included one or more federal candidates. And so when you look at that, Alpha, anybody that's ever prosecuted cybercrime before knows that the number one most important piece of evidence are the logs. And there's all sorts of logs. There's system logs, there's events logs, there's there's all sorts of logs, but they all need to be retained. And for them to come out and say, well, that actually wasn't records that we're supposed to retain. And to Ash's point, this is something that goes on all over the country. I remember back around 2022 in Michigan, they had a situation where they wanted to come in and replace batteries on these machines, which means that these machines are going to be unhooked from the batteries. When you have a problem with your car, like the check engine light or something, what do they tell you to do? Disconnect the battery for 10 minutes and the computer will reset itself. Now, I don't know for certain if that's what happens, but as Ash was alluding to, anytime you do anything to a machine that has something that is by law mandated to be protected, you have to make an image of that before you do any type of update to it in the case any of that data is corrupted. Every single facet of audit laws, Sarbanes, like anything having to do with accounting, they would do that. Our elections are the one place where they're like, yeah, we don't need to retain that. It's absurd.
And those accounting, generally accepted accounting principles, those span every industry. The same audit firms audit every single industry with the same principles that tie to international principles, because this is public trust we're talking about. We're talking about auditability in capital markets, right? Being able to attest that the financial records of whatever company are true and accurate based on what the company is saying, which drives public trust in capital markets and, stock prices and all of those things. Public trust is paramount. It's very, very important. Freaking flies out the window when it comes to elections, though. And as we've discussed, Brian and I, on why we vote, and if your audience isn't familiar with why we vote, all of this we discuss in great detail with folks. We did a series of shows with Mad Liberals about specifically adjudication and what's happening in the kind of counting and reconciliation process, the adjudication of votes that the machines can't read or for whatever reason have to be duplicated, and they're operating on outside of the systems, from what Phil showed us. Outside of the systems in a way that if you're wiping the system logs, the operating system logs, you're not going to capture those things because it's not happening in the EMS. And that's what election management server software. And that's what my understanding, Brian, correct me if you understand this differently, but I think that's the distinction that the elections experts have drawn, is anything related to the EMS or the voting software, or, the system for voting. Well, that's what we have to preserve. But if we're talking about, operating system logs or other logs that are outside of the election management software, well, we don't have to preserve that. That's not election records. And
it just doesn't make don't make sense. It's like saying, here's a screenshot of your balance, but we're not going to give you a record of the transactions of how we got there.
Yeah, that's I was just thinking in my head of an analogy to make there, and that's what it would be like. It'd be like using your cell phone to commit, wire fraud, and then ignoring anything that shows the actual logs of what you did to commit wire fraud. It would just be the numbers. Hey, look, you transferred $10 million here, and that was illegal. So, all's fair. Yeah, that was a good analogy.
Yeah, I mean, I think I would think a little bit more specific to what we're talking about. Think about like your phone, right? So. Mm-hmm. I have an iPhone. And let's say my phone is hacked, and the experts that are going to help me solve my phone are only going to allow me to look at Telegram, the app, or only going to, look at the information for my mail app, not the operating system, not what runs the phone, not the things in the background. And well, the hack could come from any number of doors that are open on my phone, but we're only going to look in this one place. And then when we don't find evidence of a hack, we're going to tell you everything's fine, safe, secure. And there's, you just don't understand how phones work, right? is what we get. And that's what's crazy about this, is that it's pretty basic, security and technology stuff. And it's certainly basic from an auditability standpoint. The software is running on hardware that has, systems and logs. And as we discussed with Phil, they can go into other applications within those devices, particularly in adjudication, do a whole bunch of stuff that's not going to be captured on the, you know, the logs that they're preserving. So this was the assumption, right? Was that it's my understanding in hindsight from talking to people that were involved in the taking of images around the country and in Colorado, not just Tina Peters. Tina Peters is the one they made an example of. But that's my understanding of what the concern was of election integrity activists, is that they were going to preserve some records, wipe other records, and then when we came to a point of possibly getting justice for the 2020 election, there weren't going to be records. And so that was the premise for taking the images. Now, it's important for people to understand taking images of Colorado voting machines or of any voting machines in Colorado in 2021, when this happened, was not illegal. It's not unlawful. Other clerks in the state of Colorado did it as well. They did not get Tina Peters. She was made an example out of, and right after this, they changed the law to make it unlawful. So it's unlawful now to do what Tina Peters did. This is kind of a focal point of Brian and my coverage during the trial, is that they cobbled together this, you know, case, this criminal case against her that appeared to be trying to try her under the law they passed after.
Retro.
So it's like rule violations and, you know.
Which is not allowed.
No.
It's for everybody to understand.
Yeah. So it is unlawful now. It wasn't unlawful then. The trial, which we'll get into, was a wild ride.
It's crazy, and I didn't realize. Actually, I do now. I'm starting to remember that they did go after and make a law to do that. And it's crazy. It's like, why would you want to make that illegal if it helps secure our elections?
Well, they claim that because, you know, you have proprietary code and there's things that can impact the vendor's business profile in the whole image of the machines, that by taking those images and sharing them, and this is not what she was convicted of, by the way, or even charged with, but this is the narrative. And that's what's important for folks to understand about Tina Peters, is that there's a lot of storytelling about Tina that's not grounded in the facts of the case and what's actually happened going back to 2021. There's a lot of different narratives, some pro Tina, you know, a lot anti Tina. They're not grounded in the facts, the evidence, the law, or what happened at trial. They are agenda-driven narratives to, you know, drive social change. So Tina Peters messed with voting systems. I think that's what Jenna Griswold said last week. Not charged with or convicted of that. But that's been the narrative, right? Is that she tried to manipulate elections is kind of the top line in Colorado anti-Tina Peters message. And anytime I post anything about Tina, I get those people in my comments. Yep. She tried to steal our democracy. She stole passwords and leaked passwords. She did all these things. That's all things that the state has said about her, but it's not things that they charged her with. And it's not things that they would even allow to be brought up at trial. And that's what's crazy, is that the narrative, it's one of the things that's crazy. The narrative about what Tina did, that the state has propagated, and that the media here very dutifully carried, that narrative is detached from what happened at trial. And the state fought against her being able to talk about any of that at trial and won. She was not allowed to talk about her intent. She was not allowed to talk about why she did things the way that she did. She was not allowed to talk about what her concerns were. She was not allowed to talk about what she found, what they found in the reports that were done on the images. But publicly, in the court of public opinion, that's all they'll talk about.
It's important to understand that as the county clerk, she's an elected official, and she is tasked with the responsibility of administering the elections in Mesa County and also overseeing, you know, the election equipment. She is the custodian of that election equipment. And, you know, they put out the narrative, and Ash is exactly right. The Secretary of State's office laid the foundation for the charges against Tina Peters being because she tried to steal the democracy. She tried to hack the machines and take the machines and send them off to untrusted people. None of that was illegal. None of that was illegal.
For the big lie.
For the big lie. Now, when you actually narrow down what they got Tina Peters for, it becomes a battle of elected officials, the Secretary of State versus the elected official in Mesa County, Tina Peters. And basically Jenna Griswold said is my office is more important than yours. So everything you did was a direct violation of my office, and there was no violation of hers. What Tina Peters was doing was creating a backup system, as we've talked about, and the way she had to go about doing it while, and we'll get into the legality of what she did. I don't think it was illegal. I personally don't think it was illegal. And they make a very good case for it being illegal. They make a very good case for the entire investigation being brought under, false pretenses, things that were not actually illegal, but warrant, they use that to justify the investigation. And from there, it's investigate a person and you'll find a crime. It's that type of thing right there. It's the same thing they did to Michael Flynn, to General Flynn. They took him and they knew he didn't do anything wrong, but they kept hitting him and hitting him and hitting him until he hit some little lying to the FBI, that kind of thing, and went after him for that. They did the same thing to Tina Peters.
Yeah, and we'll definitely dive deep into that part, because from an investigator standpoint, I was like, oh, it's the way this thing even started is outside the way we operate. Consistently, it doesn't matter what state you're from. Probable reasonable suspicion and probable cause are what they are, state to state. That doesn't change. But yeah.
Hang on, just before we get into the actual trial and everything, because the whole thing that the Secretary of State said is these records were all backed up. Ash, to your knowledge, outside of Dallas, Schroeder, and Tina Peters, Mesa County, and what is Elbert County?
Yeah,
Elbert County. To your knowledge, was there any backup images created of any of the systems before they did the trusted builds on the other ones?
The state directed backups, which was to the kind of take the copy of the partial records per the instructions provided by the state.
Keyword partial records.
Yeah. And it's all I believe all of the counties, excuse me, even the non-Dominion ones did the state directed backup of files before the 2021 election. That is, inadequate in terms of the grifters and bad actors, I think they called us in Matt Crane's thing.
But did they back up the system log files, the event logs, the audit?
No, they only backed up the documents, the records that are required to be preserved, according to people like, Matt Crane and David Becker and Jenna Griswold.
Yeah, you need to put quotes around required, because you just made it
required to be preserved.
Yeah, you just made it sound like they backed up what they're required to. They didn't back up anything that would be able to be used in a federal prosecution if there was, malfeasance in it, wrongdoing.
And I do believe that there are, I don't know how much of this has actually come out, but I believe that there are other clerks in other parts of the nation that have backed up their, that have images of their machines. There are some of that. Yeah.
There. And see, and not to go too far into a segue, we'll probably end up having a part 2, maybe even a part 3 to this, is if I'm an investigating agent and I know that, because just so people understand, as an officer or a deputy or a special agent, you don't just have a duty to develop evidence to convict someone. You also have to do your investigation where you have a moral and ethical duty to make sure that if there's information that suggests a person is innocent, that you have to. And I'm not just talking about exculpatory information. What I'm saying is, if you're an agent and boom, something hits you and you're just like, hey, if I look at this and look at this and look at this, that may actually lead me to a different narrative. I have a moral obligation because of my badge to do that. And in this situation, if I learn that there's other election officials that made these backup, these preservation images of it, then what I have a duty to go and be like, let me go look at this situation and look at that backup image, and for A and for B and for C and for D, or however many exists. And if I see these all have something that's similar, which is the other machines at the time or whatever, that, because I'm by no means a tech expert on this, but if I see that they all had a consistent pattern of, there was this, rush to come in for new software, it's going to lead me to ask questions of these other places to see if there's any inconsistencies. And if I see that they're all similar, then that starts to generate, with a word that you guys are probably all familiar with, is motive. Is there another motive to this case? And if there is another motive to this case, who's behind that? And the second that reaches me, I have to go before the detective bureau and be like, hey, we have another MO, and we have another set of people that we need to look at for this MO while we continue to investigate Tina Peters or whoever it is there. Like, that's the way this stuff works.
So, hey, this is really important, because what you're touching on is the law enforcement obligation to the rights of the accused. And the rights of the accused are paramount in our system. The Bill of Rights, like several of the rights protected by the Bill of the Rights, deal specifically with the rights of the accused. You're innocent until proven guilty. But Alpha, how does that change when there is, kind of the domestic terrorism, sedition kind of thing coming into play? How does the law, and I mean actually, not ideally, how does the orientation of law enforcement's relationship with the rights of the accused, how does that change if you have some of these aggravating things like terrorism or treason?
So just to be able to understand, these things don't allow for there's a kind of a misunderstanding. It doesn't allow for your Fourth Amendment rights or your constitutional rights to just be completely violated. What it allows for,
only suspended,
is for, well, yes and no. I would interpret it that way too. So I understand that it allows for a more expedited process to get beyond that because of the urgency, because of the threat that exists. Here's a simple example. We have to write search warrants in order to get into people's phones, or if we want to ping the location of someone's phone, we have to write a search warrant for that. And everybody says, well, yeah, you should. But in the event of let's say a missing person, I get to send a letter to Verizon and be like, I don't have a search warrant yet, but I need to do an emergency ping on this phone because of this urgency. But I'm promising you that a search warrant is coming behind me. And so in the interest of the preservation of life, there's this understanding that, yes, we're going to give you this information, even though we don't have a search warrant yet. But I have a legal obligation at that point to make sure that I do send a search warrant. Now, the search warrant can't be based off of information I learned after I did the ping. It means that information was pre-existing the moment I asked for it. So had I been able to get a judge right there on that spot, a judge would have approved it on that spot, not based off of new information later. So do I make sense so far with that?
Yeah.
Because I don't want people, because I know some people like, well, then you could just develop a search warrant off what you find later, and it wouldn't work that way. You'd be liable for that. And the reason we do this is, one, there's a moral and ethical responsibility, but two, there's also a civil liability. If I'm a detective, and the reason I know this, because I actually
the reason you do it is to protect the rights of the accused, and if you don't, then there's the penalties you're talking about, right?
And I'm aware of this because I was actually involved in a situation like this, where I was one person in the bureau that received information from a partner detective on two suspects that we had in custody. And so I told the lead detective and the assistant detective, these are not our people, and this is why. They didn't want to listen to me. Told the detective lieutenant, went through this whole chain of people. And then ultimately, and I'm summarizing a story here because it's actually tied into my personal story. That's why I'm very dialed in on this particular thing. So eventually this person sues the department over $250,000. Rightfully so, because they shouldn't have been arrested. And then now we fast forward about a year to year and a half later, because of that lawsuit, the department's looking to penalize someone. Someone has to be held responsible for that, and they should. It wasn't the detective lieutenant. It wasn't the detective sergeant. It wasn't the case agent. It wasn't the assistant case agent, because one of them was working at a new agency now. They came after me, and I remember saying, "What? You guys are insane. I'm the one that was telling you." And so this actually got brought up into my trial with my agency, where my attorney ended up telling, the only thing left he could have did was break the person out. There's no other steps he could have taken. Now, why that's interesting is because had I not taken those steps, they actually would have had an argument and actually would have made me civilly liable for that, because I would have operated outside the scope of policy. That's what you have here in this case. The second, and I know we're going to get into that video later, the second that officer realized that the federal agents didn't give him all the information, he had an obligation, not a suggestion. He had a legal obligation to call them and ask them why. It doesn't matter if it was during the investigation or during the trial. The second I would have got off the stand, first thing I would have been doing, I would have been on that phone. I would have contacted them. Who provided me the Celebrite information? And then I would have contacted them and I would have said, hey, is there a legal reason you didn't provide me this entire thing? Because you just made me, because I could be Brady'd after that.
Yeah.
And unless you have, well, there was classified information, and then I'll be like, okay, provide me the statutes of why you did it. And I'm going to write a supplemental report right now while the investigation is going on, saying on this day I contacted so-and-so because I received information that I barely learning that I should have had. And according to them, it wasn't provided because it was classified under this, this, and this, and this. That's what I would have done immediately to cover my ass. And in this situation, we don't know if any of that happened. All we know is he wasn't given full discovery.
And when there was a problem, they tried to scapegoat you for it, right? And that's so, you know, if you watch like Law and Order or any of those kinds of shows, you see all this tension between these different positions of public trust, right? And in the shows, they're, you know, generally trying to do the right thing and find the most justiciable outcome. In the case of Tina Peters, you had all of the government agencies, state, local, and federal, aligned, basically had determined her guilt prior to she was even investigated. And they co-signed each other's bullshit, right? So at her trial, you had the Mesa County DA as the lead prosecutor. Then you had the AG's office there as well, and, you know, right alongside, ask some of the questions, making objections. You also had the DOJ. I think they were present for at least part of it, but there was several times during the trial where people were Sharona Bishop was on the stand. She was being advised by the court and by I think it was Dan Rubenstein, you know, that there's potential federal charges that you're, you know, may be on the hook for. This is how I remember it. I'm not quoting directly. You know, you need to be careful about that because you could incriminate yourself and you have no immunity over, you know, anything outside of the scope of what's happening here. When you have all of the, because what you're describing, Alpha, in terms of the way that it's supposed to happen to protect the rights of the accused, is you're describing a series of checks and balances. But what happens when those entities that exist, you know, in this interoperable relationship with each other, but with the, you know, kind of contentious, it's designed to be contentious so that they're checking and balancing each other against the law, because we're a rule of law. What happens when they're all on the same side and have decided the guilt of the accused? Because, listen, it's really important. It's our democracy and it's a threat to democracy. And so we've got to do everything that we can to make an example so that nobody else decides to be a threat to democracy. That's what happened in Tina Peters' case. There were no checks and balances, and there was nobody looking out for the fucking rights of the accused.
There's only 3 checks and balances that exist that can help you in the situation you're describing. And as you progress in each one of these, they have less and less power to help you. The first one is the judge. During the course of a trial, the judge is the arbiter of making sure everything is done to perfection. As a matter of fact, to what you're saying, that maybe it was Dave Rubenstein that said, hey, there's these potentials. The judge will come out and do that. I've been in a trial where the attorney is getting exactly what he needs out of a witness, and the judge interrupts the attorney and tells the person on the stand, hey, just so you understand, anything you say right now can be used against you and charges can be brought up against you, and you are entitled to your Fifth Amendment. In other words, the judge is essentially telling him, you better shut up, stupid, right? Yeah. And, you know, you can look at it several different ways where, like, judge, stay out of it. You know what I mean? Like, no,
they're the ref, right? They're calling balls and strikes.
It is. And whether the judge thinks the person is guilty, he's the arbiter to make sure that's right. So that's the first one. The second one after that is the appeals court. Now, the reason you lose power as you go through this is because if that first arbiter keeps information from entering into the court record, then that's the information that an appeals court would need. So just so people understand, and I'll put an asterisk here because there's weird situations, but typically if you develop new information or you had information in that case, and you're like, well, we'll just bring it up in appeals. Appeals is only going to address the things that were on the record. So if you have a judge that's not doing his job or is compromised, then that sets up the appeals case to not go your way.
Oh, well, or shitty legal work, right?
Or shitty legal work from your attorney.
I think Brian knows because we argue about this sometimes. But like a lot of judges get blamed for outcomes often that are the result of shitty legal work. So if in your example, right, there's information that they want to get into the record, they can't get it into the record. So they say, okay, we'll just bring it up on appeal. There is a way to appeal the decision to not include it in the record, right? So if you try to bring it in and the judge turns it over, that's appealable. Yes. But if you don't, right? If you fail to make part of your case, if you think, oh, it's fine, we'll just get them on the stand, and then for some reason you can't get them on the stand, that's shitty legal work. That's not the judge's fault because this is a very rule-bound process. Now, can it be manipulated? Absolutely. When the people that are responsible for preserving public trust are manipulating the outcome, which I think is what happened in this case. You talked about the judge kind of setting the guard. This is a jury trial. And so like the stuff we talked about, you have exposure for, federal crimes. So don't talk about these things, whatever. None of that's happening in front of the jury. The jury is the finder of fact. There's the majority of the trial happens without the jury present. It's the procedure and the what's in and what's out. And then what is presented to the fact finder is what the decision of the jury is based on. But there's a lot of stuff that happens that determines what the jury gets to see. And one of the things that I think is one of her strongest points of appeal is that she was not allowed, I mentioned this before, but to talk about her intent, to talk about why she did things the way that she did, to talk about, why the credentials, we'll get into that a little bit later, but why that was necessary, or to talk about what she found. The judge limited all of that from being presented to the jury. Now, that's within the judge's discretion. He thought it was irrelevant, and that's fine. But when it came to her sentencing, and he delivered his reason for the severity of her sentencing, he invoked a lot of stuff that he did not allow to be presented to the jury. So he's making a decision about her sentencing on the full record, including the stuff that she's asserting, right? I didn't trust Jenna Griswold. I thought that they were going to wipe election records. I'm an elected official. I have a statutory authority to preserve election records. So I'm taking the steps, and I thought it needed to be this kind of guy, and I needed to get that guy in. And then Jenna made emergency rules ostensibly to stop us from being able to, have people observe. So there's this Tina Peters investigating elections as part of her job as an elected official with oversight of elections, and taking steps to do that. Now there's, questions about those steps. Did it have to be that way? Why did it happen that way, et cetera? But she wasn't allowed to talk about any of that. But then the judge in sentencing invoked all of it to give her a super harsh penalty. That to me is a violation of the rights of the accused. It's a violation of due process. And it's one of her strongest positions for appeal, is that the judge was not the referee, not the calling the balls and strikes. The judge was prosecuting the case with the prosecution. And they had all decided the convicting information in this was that the credentials used by Conan Hayes were the credentials of Terry Wood.
Hold on, I don't want
way ahead.
Yeah, I don't want to. Yeah, I don't want people to get too lost with the ending of the story before how we got
in the middle. But okay.
Well, real quick, one thing that Ash did bring up there, the emergency rules that were created to kind of what we believe to distract and dissuade Clerk Peters from being able to do this. Those emergency rules were deliberately to obfuscate transparency in the name of COVID. Just want to throw that out there.
Yeah.
They were saying that COVID is so deadly that we need to turn a blind eye to the potential wrongdoings and how we're going to do this trusted build. Nobody can oversee it. It's almost like they realized they got caught, or that people were going to scrutinize this, and so they did something to try and stop that from being able to happen.
there was a lot of weird things that
Yes.
happened, like during COVID when it came to the courts. Like for
Yes.
instance, when I went to I remember my first hearing, they're like, you gotta wear a mask to come to the court. I'm like, I'm not wearing a mask. I'm not. They're like, well, if you don't have to, but we're not gonna let you in. And I'm like, well, I have to have a mandatory appearance, and they're like, well, you have to wear a mask to come in. If you don't, we're not gonna let you. And if we don't let you and you don't go in, then we're gonna arrest you for a failure to appear, which is a new charge. And so the predicament for me was, because now I'm out on bail. If there's a new charge while I'm out on bail, well, then you lose the right to be on bail. You get rearrested, you get thrown in there, and then you're going to be coming up with bail money all over again with these new charges. So there was a lot of weird stuff that happened.
So you wore the mask?
Yeah, I had to. I just couldn't risk it. The pros versus cons on that one. But
go ahead.
Yeah, but I was going to say to that situation, I want to say this before I forget. A good attorney, a defense attorney, is going to do a motion to quash on the search warrant on these cases, and part of the reason is because you want to get a motion to quash so that you can make this whole thing go away. But the other reason you're going to do that is because it's going to be one of the most detailed arguments of your case that's going to make its way to an appeal. And so a lot of stuff that, like you're saying, where the judge said, well, that's not relevant, because the judge is trying to keep it to the information that's relevant to the specific charges. Well, in that motion to quash, you're going to be addressing stuff that's on everything. You're going to be addressing, because you can navigate through stuff and see, well, they're probably going to potentially add a charge, which the prosecution has to be very careful with that, because it could look like prosecutorial misconduct depending on how they go about it. But you're trying to navigate their game plan to incorporate all this into your motion to quash. And so this way it happens. So I'm curious to see if any of these types of things were done, or certain motions were done to help Tina, because her case should have had a lot of motions, and at a minimum should have at least had a motion to quash at least once.
Yeah, I don't know the full record of all the motions over the course of the 3 years that she had a bunch of different attorneys, and there was a lot there. The specific rule that Brian mentioned, the COVID rules. This is really important because it forms the foundation of this entire thing. It is the crime, the underlying crime. She wasn't convicted of the underlying crime, but is what they asserted was the underlying crime is that she disobeyed Jenna Griswold. That rule, COVID emergency rule, was that nobody could be in the office except employees. And it was for COVID. It was, we have to limit who's in these offices when we're bringing in the people to do the trusted build and all these things. Prior to this emergency rule, Tina can have whoever she wants in her office. She's the elected official. It's her office. It's, a matter of public trust. She can open it up to everybody, but not in 2021 because super dangerous COVID, and we got an emergency rule. And, during, I'm going to say, I know this is jumping ahead a little bit, but it's important to the point as we set up going into the trial. During the trial, the court qualified Caleb Thornton, who is an attorney from Jenna Griswold's office. So Jenna Griswold is the aggrieved party, right? One of the aggrieved parties. Her staff are the, Mesa County too, but they're the ones who were violated by this misrepresentation. Caleb Thornton was qualified as an expert to explain to the jury how COVID rule violations, along with the kind of professional conduct statutes that exist for elected officials, when you mush these things together, you get this very serious crime that is warranting of, 6 felonies and 9 years in prison. Qualified a member of the aggrieved party as an expert to explain the law to the jury.
This is where
the judge explains the law to the jury, by the way. That's usually restricted. Lawyers are not allowed to explain the law to the jury, except, when you need to qualify, when the judge can't do it because it's such bullshit.
Hang on, because you're completely and totally conflating law with policy and rules, because that wasn't law. That never went through.
Part of it was
Colorado
law because it was the combination of the COVID rule with the existing statutes, and the testimony was these things combined create this horrifying crime. Trust me, bro.
Right,
Yeah.
right.
And
Okay.
and see, and the difference there is the law's the law. That nothing gets to piggyback
Not
a
in
law.
COVID alpha.
Yeah. Well,
Yeah.
I know, and I understand.
Genuine circumstances.
Well, this is the same situation where let's say I would have just took on the gauntlet of saying, well, I'm not going to wear my mask, and they would have said, okay, well, now you have a failure to appear. Well, technically, when I go to court on that, I should win that 100% of the time because there is no law to support it. There's a mandate, there's a policy, there's you better do this, but it's not. If it's not written in law, then us as law enforcement officers, hands are tied. Period. That's the end of the story. Your hands are tied. You have to go and create that law if that is what you want. And then there's a process for all that to happen. In this situation, it didn't.
Yeah.
So
yeah, I mean, so for law enforcement, yeah, your hands are tied. For executive branch bureaucrat people, they just reinterpret the statutes. And that is what happened here is, with this kind of creative lawyering to put together this case that, as I said before, appeared to be them attempting to try her under the law they passed because of her, which is just such a violation of due process and of our justice, principles of justice. And it's manifestly unjust, in my opinion. And then when you look at the sentencing, just mind blown.
It's crazy. So let's do this because I know we want to get into the court, but I want to cover the segment of this saga of, so she does she makes the preservation image or the image of the machine. Between that and when the court happens, what all happened to her? I know that all of a sudden we see her, to the symposium, and then we see the things that happen. What's all the window of that and the order of how that all kind of unfolded?
So August 2021. So the images were taken in the spring. And at some point, I think mid to late summer, the state got wind of what was happening, with images being taken and whatnot. And again, these conversations were happening all over the state of Colorado. I think all over the country, but certainly all over the state of Colorado, the images were being done in different counties. The images that Dallas in Elbert County took are the one example that's very similar to Tina Peters. There's two key distinctions. Dallas took the images himself. He did not bring anybody else in to take the images. He took them himself, and he's on camera while doing it because he did it in the office and the surveillance cameras were turned on. And so, that supports Dallas not being prosecuted. But then the other thing is he didn't have them analyzed. So he took the images and then held them, hoping for court to demand that they, and working towards that, right? Working towards the outcome of a court demanding that they be analyzed. One of the best, this is a bit of a side note, but it's kind of fun. One of the most explosive moments was when Dallas was in court with Jenna Griswold's office, and in court proceedings, and one of the filings mentioned the images. And that was the first time Jenna Griswold's office found out that images had been taken in Elbert, was in a sworn court pleading that acknowledged their existence. And she lost her mind. There was a coordinated press campaign about how Dallas was the next Tina Peters and threat to democracy and all of these kinds of things. Massive pressure on Elbert County. Elbert County still has different treatment from the Secretary of State's office than other counties because of that, but they were never charged with any crime. They were never, aside from the process being the punishment and the weaponization of government and abuse of power by the Secretary of State's office, nothing happened to Elbert County because it wasn't unlawful. Taking the images was not unlawful. The reason that Tina Peters is, the best one for them to make the example of is because of the manner in which they were taken. There is that COVID rule violation that leads them to be able to turn it into, oh my God, she stole passwords and leaked them and all of the things they've said about her, which are bullshit.
And just real quick, a teaser. for part 2 of this. Wait till we get into what was found.
Yeah.
I'll just leave
Which
that at that.
people can read, you know. I think the Mesa 3 and 4 are up on the Cause of America website. I think probably all 4 are up on the Cause of America website, causeofamerica.org. Mesa 1 and 2 are up on the USEIP website, useip.org. You can go and read the reports and see what was found. We will summarize them in part 2.
Ash is not very good at selling a show.
Well, everybody's going to want to watch part 2 by the time we're done with part 1.
All right.
Oh, yeah.
I'm trying to pump something up, and Ash is like,
You're
could just
pumping it at the inappropriate time, though, because
You
we're
don't
in the
need to
middle
watch
of the
this.
show, not at the end of it.
I was like, that was a really good hook.
I'm trying to hook them, and
Right put out there.
Ash is like, cut the line.
It still blows my mind that people don't know what was found in the Mesa reports.
I
And I
know.
know they don't. I know there's people that don't know Tina. There's people in Colorado that don't know who Tina Peters is. It just blows my mind that people can be this oblivious to just
And we'll play
what's
the
happened
clip,
in my state.
and we'll play
Well,
the clip of Ash and I interviewing Dallas Schroeder as well, because he had a shocking revelation during that.
Well, every time I have the meeting with you guys, there's more information that I learned that shocks me. It's wild.
Told
All
you
right,
about
so-
them clips.
So this happens, and then so how does Tina end up getting in the public spotlight?
Okay. So the Cyber Symposium was August, I believe it was 11th, 12th, and 13th of 2021 in South Dakota. Mike Lindell was bringing in, folks will remember this, right? The PCAPs and the election data from 2020. There was a $5 million challenge, and all the cybersecurity experts from around the world were coming in. This is the story that was told. Also, activists from around the country coming in. I think all 50 states were present.
Yep.
People from all 50 states, elected officials from all 50 states as well, either elected officials or candidates from all 50 states present at the Cyber Symposium. And Tina Peters and a group of folks from Mesa County were brought to the Cyber Symposium on Mike Lindell's plane. Now, this was I'm going to try to back up. At the same time, so I think it was when Tina was on the plane coming to the Cyber Symposium, her office was raided by Jenna Griswold. And it's my understanding that it was a staffer within the office. And I don't have it independently confirmed 100%, so I'm not going to say who that staffer is, but there was a staffer in the office that was, so God, this is so complicated. There was beef in the office when Tina won. So Tina won the election for Mesa County Clerk and Recorder. The clerk and recorder that she replaced was a woman named Sheila Reiner, and Sheila was termed out. So she was running for treasurer, won treasurer, and kept her Dominion credentials. Weird, but she had loyalists in the office, and it was contentious. And Tina had made allegations that there were attempts to sabotage her, like ballots and drop boxes and things that made the office look bad, that she was brand new in the office. And so it was, a setup for her kind of thing. But there's beef in the Mesa County clerk's office. It was a contentious election, and Tina wasn't supposed to win, right? Sheila Reiner's this is the story. Sheila Reiner's handpicked person didn't win. And, that was a point of contention. And so the story, as I understand it, is that a staffer in the clerk's office whistle blew to the Secretary of State that this whole image thing was going on, but specifically called and told them when Tina was on her way to the Cyber Symposium. And that's when they decided to raid her office. So it's, and again, my understanding on this specific sequence of events at the cyber, the Cyber Symposium stuff might be off in terms of sequence a little bit, but that's how I understand how that happened. Is she's on the plane on her way to Cyber Symposium, and her office is raided, and there's a press conference, and Jenna Griswold and Matt Crane are talking about how, this is a massive threat to democracy, and she stole passwords, and she put passwords on the internet, and she's trying to, undermine all of the confidence and all of the elections and all of those things. And so the Tina, who I believe was just intending to be attendee at the cyber symposium ends up being the story at the cyber symposium, because all of this happens while it's going on. Brian, anything to add on that?
No, you're spot on. And that's how it was conveyed to us at the symposium, that they raided her office while she was on the plane. And, you know, when she got up there to speak, you know, there was a lot of, you could see the emotion. It weighed on her tremendously with everything that was going on up there. She was up on stage at the time at the symposium with Colonel Sean Smith. Sharona Bishop was up there. And then, of course, Mike Lindell was up there as well. And they were talking about what was going on and everything. It was definitely interesting. That was our first exposure, my first exposure to Tina Peters. I think Ash had kind of knew about her before.
I had spoken to her on the phone specifically about, I mentioned the ballots in the drop boxes thing. There was stuff happening in her office, and one of the people that I knew from, you know, the activism of election integrity had kind of told me about it and asked if I would talk to her. I had one phone conversation with her where she explained that just prior to the first election that she ran, there was a bunch of ballots that had been left in the drop boxes. And so it's like old ballots from an old election mixed in with new. And it was a kind of, embarrassing scandal for the new clerk in her first election after being elected. And there were other things happening too. And she was kind of investigating it. We had a conversation about that, but I hadn't met her and I had no idea. Like I mentioned, there were people looking at taking images in Colorado. I was thinking that we were going to be able to do legislation, to amend elections. Is so naive. And then we started canvassing and that took all the attention. So I found out about this whole image thing at the cyber symposium.
So let me ask you guys this. And I know we're going to go into this in much greater detail later, but just for the audience that's watching now, so she's getting rated. So does she become the spotlight at the symposium because she's being rated? Does she become the spotlight at the symposium because people know that she has this image? And if that is the case, what is the allegation that is in this image in its simplest form that would make that so important to everybody?
So I'll jump in on this one because this is an opinion that might not be popular with everybody out there. But the symposium at that point, before Tina Peters showed up, the symposium had pretty much fallen apart. There was, some concern about what was actually provided to the the technology experts, whether or not the PCAPs were real. There's a lot of, Dennis Montgomery, the guy that was supposed to provide them, allegedly had like a heart attack or something and was not able to get the information. A stroke. There you go. And so ultimately, and this is my opinion, and I shared this opinion with a lot of people that were there at the time, was that this turned out to be not what it was supposed to be. And Mike Lindell has gone through lawsuits as a result of this. He's been sued. I think Harry Hursty sued him, or not sued him. They went through like a mitigation court or something like that. Now, I always said that what happened with, like, if Tina Peters hadn't showed up with those images and the work that was done, the Ron Watkins video that was played and all of that stuff, the symposium would have been a complete wash. But that was what actually saved it, actually put some significance behind what was disclosed there. Now, that's not to say that I'm not going one way or the other on all the claims that were made prior to that about the PCAPs and all that. I just don't know enough about it to say one way or the other. But Tina Peters and that forensic image definitely created some, kind of momentum behind the movement. It saved it, in my opinion.
Yeah, I mean it's a fair assessment. I think very diplomatic assessment.
I'm trying to be diplomatic. There is,
there will be more parts to
yeah.
You guys, we'll say that. And I know,
and this isn't. I mean, we've talked about this on the air, particularly during the Mike Lindell trial, which the cyber symposium featured prominently. why this is so important to Tina Peters' case is that the cyber symposium is a critical part of the benefit harm theory of the state's case. And this was explicitly asked by the judge on certain charges. What is your theory of the benefit harm? And they said she did it for the fame. She wanted to be on the plane. She wanted to be in the inner circle, and she wanted to be on the stage at the cyber symposium. She wanted the fame. She wanted to, be an election influencer, big lie kind of person. And that's what drove her. Now, that's fucking bullshit.
Yes.
And I can tell you that because I was there and I saw Tina. It was the first time that I met Tina was right before she went on the stage at the cyber symposium. She was in shock. She was terrified. She, wanted to do what was right, but she didn't have a counsel with her. She didn't have, her own attorneys to advise her about whether, and as her office is being raided, right? And so the state's benefit harm theory about Tina Peters just wanted to be famous, that is disputed by the fact and, my personal experience with what happened there. I think that was always the state's intention was to make an example out of her, and they did.
100%. She was clearly distraught about being, like, emotionally distraught. You could see it in her eyes while she was up there. This was not something especially because at the time, now I don't know whether or not this is true, but we were being told over and over again that this is being watched on live stream by like 2 million people or something like that. That's a big number. That is we're used to talking to a couple thousand live and then, maybe 100,000 overall. Imagine 2 million. That's pretty stressful for somebody that's never been in a public spotlight like that.
Well, and going back to the point, sorry, Alpha, just real quick, going back to the point about, is it the judge's fault or is it the lawyer's fault? At Tina's trial, nobody was brought in to testify to her state of mind at the point that she went on the stand. Even after it was explicitly stated that the state's benefit harm theory was that she was attempting to, get famous off of this, there are dozens of witnesses that can testify with firsthand knowledge that that's not true, and none of them were called.
The state benefit harm theory, and correct me if I'm wrong on this, Ash, but this is around the I think it's one of the Colorado statutes about attempting to influence a public servant, where you have to have some sort of gain that you're getting from doing that. And that was the gain that they were alleging, was that she did this for fame and notoriety. Yeah.
And so there's 4 felonies that she was convicted of. And the 4 felonies are misrepresentation to a public official with, as Brian says, the attempt to get some gain out of that. That is the representation of one of the person that took the images as someone else to get around that COVID rule violation. That was Tina's, intention for doing it that way. She was never allowed to talk about that. And this is also why it's problematic, is that the benefit harm theory is the benefit or harm assertion provable at trial is required by the statute. That's the state asserting her intent. Right? She did it because she wanted to get this thing. She did it because she wanted to get famous by being on the stage at the cyber symposium. But Tina was never allowed to talk about her intent. So she was never allowed to dispute the benefit harm theory. Again, I think these are grounds for appeal, because this was, and Brian can attest to this. When we started covering the trial, when we start covering any trial, I do not start from a position of the judge is corrupt. And I rarely end at a position of the judge is corrupt. I'm usually most hard on the lawyers, because they're the ones. This is your moment, right? You're at trial. You've had a long time to get to this point. This is your moment. Fight to win all the way. But by the midpoint of this trial, he at the beginning of the trial, he was showing open bias against the defense. Now, this had been going on for 3 years. There's a record there. There's, back and forth and annoyances at the judge and all of that kind of stuff. But he was not showing that open bias in front of the jury. It was very fair in front of the jury until like the midpoint. And then you started seeing the bias displayed in front of the jury. And we had a lot of restrictions and limitations, like Dallas Schroeder. They brought up Dallas would be able to talk in great detail about why Jenna Griswold's office, was suspect and why clerks were concerned about what was happening. He wasn't allowed to. They brought him on the stand. They swore him in. They had a real long sidebar, and then they dismissed him.
Literally like a 30-minute sidebar. And then they asked him like one question. They're like, okay, you're dismissed.
I think they just asked him his name. Like, I think he literally just read his name into the record, and that was it. Yeah.
I think you're right.
That's wild. Real quick, because I don't want to get too far from it. I want to make sure the audience.
And Alpha, check the private chat when you get a sec.
All right, so we're back from the break. So here's the question that I have real quick. I want to make sure that my audience has an understanding of this. What is the allegation or assumption that is in this image that Tina Peters has that the state or the election officials are so afraid of?
You talking about what was found, or are you talking about what their assertions are?
So when Tina Peters took this image of these machines, and I know we're about to get into what were the actual charges, and then through the progress of that, we'll see how it actually ended up on what she was convicted of. But when she took the image of these election machines, or the election machine, what is it that people are anticipating that is in that image that could probably expose potential fraud? That's what I'm trying to get at. Like, what's in that magic card that may reveal something that is a concern? Because I think a lot of people are struggling to believe that, oh yeah, we know this is what they charged her with, but what is the real concern potentially that they have? What is it that she has in that image, or any of these people that took images? What is their concern of what people have in that, or what can be found from that? What's the assumption?
So just going to throw this out there. I think this is best served for part 2.
Okay.
I really do. Because and for part 2, we'll probably have somebody else on as well with us that can explain from a tech standpoint, viewpoint, like more in depth than Ash or I could. I'm sure Ash can, though.
Well, no, I mean, I think that's right. And I think it is better, the detail of it. I would say what they said, Alpha, is, well, first of all, originally she was accused of stealing passwords and leaking passwords and a bunch of stuff. When it came down to the threat of the images and what that was about, it gets to the proprietary source code, the proprietary nature of the machines, and that it's a violation of the contracts, and that touching the machines can end up decertifying them, and that creates a greater financial burden on the counties and things. So there were a lot of arguments that were put forward as to why this was such a big deal. To Brian's point, I don't think those are true. I think that the real concerns are much more sinister, and we'll talk about that in part 2.
There you go. Now that's the way you guys hook up part 2 for me, audience. They got me. They got me hooked for part 2. They got you guys hooked for part 2. So
I got to make sure I don't let Ash respond first, and then we'll get the hook. Otherwise, she'll just
actually. If you bring me into the hook, it's better. I think is what the lesson there is, Brian.
You guys, if you guys want more of this, Why We Vote on Badlands, you got to make sure you follow them, as well as make sure you're following Brian and Ash's independent stuff. All that linked down in the description. We'll talk about it again at the end of today's part 1. So let's get into the court part now. What was she actually charged with, if you don't mind reading that to us?
Absolutely. And so I'll read what the charges are, and then after we go through kind of the trial and the videos, I'll read what the convictions are in the sentencing. But I'll read the sentencing guidelines now, and we'll talk about what she was sentenced with later. So 4th degree felony, attempt to influence public servant Jesse Romero, worked for the Secretary of State's office. Sentencing guideline, 2 to 6 years presumptive prison, 3-year mandatory parole, and $2,000 to $500,000 in fines. That's the guidelines, not what you got. Attempt to influence public servant David Underwood. I believe he was Mesa County IT guy. I have to go back and look exactly, but that's how I remember it. Sentencing guideline, 2 to 6 years presumptive prison sentence, 3-year mandatory parole, $2,000 to $5,000. On these first 3, the sentencing guidelines are the first 3 felonies. Sentencing guidelines were the same. Conspiracy to commit criminal impersonation. That's a 6th degree felony. Attempt to influence public servant Danny Casillas, another Secretary of State official. Same sentencing guideline as before. Criminal impersonation, 6th degree felony. Conspiracy to commit criminal impersonation, 6th degree felony. Identity theft, 4th degree felony. Official misconduct, misdemeanor 2. violation of duty, misdemeanor 1, failure to comply with the requirements of the Secretary of State, misdemeanor 1. Those are the 10 charges that were the substance of this trial.
Interesting. And does it give what was she looking at as far as time wise when all this
I wrote that somewhere because I think I did the math on it, but
the max charge, I mean, if they're going to run consecutively, is 6 years, and that's the book. The book. And we'll
for
get
each one.
For each one, right? Well, if they're going to run consecutively, I would imagine we'll get to all that stuff at the end. We'll break that down because it's very important, and that's where that message will come in at the end here too.
And that was what she was charged with. And as you know, after we get through the trial, we'll talk about because she was acquitted on some of these charges and she was found guilty on some of them. So
correct.
And as far as you guys are aware, was she ever offered a plea prior to?
Yes.
She was. Okay.
Yeah. She refused to take it because she was going to fight this for, I think, honestly, in her heart of hearts, fight it for elections. I also don't believe, this is something that people give me shit about all the time, because, people say like, declare her a federal whistleblower on elections and move her out of the state courts and get her into federal custody and, do these extrajudicial things to save Tina Peters. And I know Tina Peters, and I actually asked this like a month or so ago of a friend of mine who is a very good friend of Tina Peters and visits her regularly. And I said, I'm getting shit for saying that, extrajudicial things to get Tina out of prison at the expense of election integrity is not something that she would want. And that was confirmed for me 100%. She does not want the laws to be broken to get her out. And probably part 3, we can talk about the whole federal whistleblower thing.
Well, I think the federal whistleblower might be relevant during one of the parts that we're going to play here, and we'll unpack that when we get there. And I want to get Alpha's take on it as somebody that's been in law enforcement, dealt with federal law enforcement, and see what his take on that is. So when we get there, we'll cross that bridge.
Cool.
Okay, so let's get into the trial then. Do you guys want to start with the 18-minute video, or is there something you want to talk about before we get into this video?
I think it's more important to set up the predicate of why they began the investigation. So I think that's the 18-minute one.
Okay. All right.
Literally what he just said.
I don't know.
All right. So here's the 18-minute one. When you guys want me to pause it, just let me know. And if the volume is too loud, let me know. If it's not loud enough, it's already maxed out. So I can't increase it, but I can lower it. So here we go.
I'm good at editing, so I think the volume should be good.
Yeah. It was
Were you working that day as a DA investigator?
Yes.
Did any unusual requests come to your attention that particular day in the morning of Monday, August 9th, 2021?
Yes.
What was brought to your attention?
Office got a phone call from the Secretary of State, Chris Bial. My office was notified that there was an alleged security breach at the Mesa County voting office regarding that there had been a software.
This James Cannon?
Yes.
Okay, so James Cannon is the investigator out of Mesa County DA's office. Real busy in the 2021 timeframe, James Cannon, all over the state. And so I just wanted to make that clear for people so they know who's on the stand.
Okay. Upgrade back in May 2021. And there was a video of the software upgrade, basically I would describe it as someone filming behind somebody, like over their back, that was clipped in different pieces of a video and posted online. And in addition to the passwords specific to the Mesa County voting machines, those were online. And the Secretary of State was coming to Grand Junction the next day with the team to do an administrative inspection. I learned that there was an election order ordering Clerk Peters to produce certain things regarding these allegations. And the notification by Secretary of State is because they were doing an administrative or civil inspection, they were giving me a courtesy notification in the event that criminal acts were determined. That would not be in the Secretary of State's venue, that would be mine. So they wanted to let me know ahead of time that they were coming in case I wanted to do any type of criminal investigation and be aware that that was coming.
Okay. So now that that foundational information had been provided to you, what subsequent decisions or acts did you take in reliance on that information?
So I had to determine whether I was going to start a criminal investigation in the event that there was crimes that had occurred, to be on the front end of that as opposed to getting information who knows how long later regarding that. And so I opened a criminal investigation.
What was your initial investigative strategy based on the allegations that you just summarized being presented to you? As you were triaging and deciding an approach, what was the approach that you decided that you would attempt to do that morning, the 9th of August, 2021?
So due to the fact that there was passwords that were captured on the internet, I was able to see these both by my own observations on the internet and information sent to me from Chris Beall. These passwords appeared to be on a computer screen, and the video appeared to be a video of computers with people talking. Their voices have been changed, so I couldn't tell who it was. They kind of sounded like really deep, like robots. My impression that somebody had intentionally or obviously changed the voice so you couldn't detect who they were. Knowing that, I then turned my attention to the video camera system in Mesa County called a Vigilon.
All right, pause it there for just 1 second. First and foremost, Alpha, my editing skills, I guess, aren't as good as I thought. Maybe turn it down like halfway, because it's blowing my ears out a little bit compared to you guys speaking.
I just turned my mic down or my speakers down.
Yeah, but I'm thinking for the people that are listening. I don't want to them to have to keep adjusting the volume on the stream. Alpha, you're a detective. You're a professional, a certified expert in warrants. Now, granted, that's California, not Colorado. What's your take on predicating a criminal investigation to get out in front of something without any evidence of a crime being committed?
The approach is what's here. He could have said it's tomato is what it comes down to, and like I said, I'm willing to give some leniency here on some of these things. He can do it if he wants to look into an inquiry, and this is where you get into reasonable suspicion versus probable cause. Reasonable suspicion, that threshold's very low. An investigator, an officer believes that a crime is occurring, right? For example, it's 4 a.m. in the morning and you're going by a commercial district of electronics store, and behind there you see a guy with a hoodie and he has a TV in his hands, right? You're allowed, you could do like what's called the Terry stop is what they went into, and a temporary detainment to see if this is what it is. That's reasonable suspicion. You can't get a warrant with that. You can't make an arrest with that. You can't do any of these things, and everything's going to be, to a point, mostly consent. Because like I said, that Terry window for the detainments, it's very limited. So in this situation, if he's getting information that a crime is occurring and there's enough there to articulate reasonable suspicion, then yeah, he can come along for the ride. He can observe, but he's going to be very limited in the scope of what he can do.
So you use the analogy of the guy carrying the TV in the back of a whatever, and if as a cop, reasonable suspicion, you go up to him and you say, "Hey, where'd that TV come from?" And he says, "I'm carrying it from my house. I'm helping my buddy move. He lives right over there. I'm taking the." It's not a crime, basically. You approach the person, you see that what you perceived happening is not actually a crime. What happens next?
Yeah, it's very limited scope of stuff. So he says that, and I see that, and I see, maybe he has a receipt, maybe he has a text message showing all this, and it shows, okay, there's no crime. It's done.
Right.
It's done. You move on. Have a good night. Sorry for disturbing you, man. Just, trying to keep the community safe. Yeah, I appreciate it, officer. And that's it. That's the end of the scenario.
All right.
Now let's say he tells me that story, but he doesn't have anything with him to prove that. Then I'm allowed a very limited window where I can probe a little bit more. Well, okay, do me a favor, call your buddy. And then you call your buddy, your buddy's like, yeah, man, he's on his way. He should be at this address. Here's the thing. Okay, then I'm done. But let's say it gets to that point and buddy doesn't answer the phone and all that other stuff. At that moment, I'm looking at the business, you know what I mean? There's no pry marks, there's no broken windows, there's nothing to support, that there was a theft here. At that point, now you're at a critical juncture as an officer. Do I have probable cause to move this to the next level to get a search warrant? And if it's not there, it's not there.
How much of that is discretionary?
there is discretionary. It's hard because it becomes very subjective. It's, it comes down to what a reasonable person think that this is a reasonable set of time. And I do think that there are some times that are dictated out there. I think like a traffic stop, I think it's like, and it's been a couple years, folks, so forgive me here, don't hold my feet to the fire, but I think it's somewhere between like 7 and 10 minutes or something like that. It's limited. It's very limited, and it shouldn't shock the conscience. And like I said, but if you don't have it, this is the thing, and we used to train this with the cops. If you don't have it, you don't have it. You let it go, you catch them another day. That's just the way it works. Now, in the situation of the TV, this is what I would have done. I can't prove that there's a crime that's here, and I can't prove this guy's case. He had a valid ID on him, so I know who this guy is. I have his phone number here. If it turns out in the morning I get a call from the business and we got stolen, then I can carry on the case with the information. But at this moment, at this juncture, it's done. The guy's getting let go. That's just the way it works.
Okay. I don't think it'll rise to that level, but we'll see. Let's keep going.
And just go thumbs down if it's still too loud, and I'll lower it.
It sounds good to me now. Should we speed it up a little bit?
You guys tell me.
It doesn't matter to me. Oh, and just to be clear, like when I edited this, you'll see like there's a lot of jump cuts. I did not edit any. If I'm playing a segment, that is the segment in its entirety. There's like hums and stuff that I cut out, like 30-second pauses where they're thinking. I cut that out. So if you see a jump cut like that, nothing is cut out in terms of substance. If you see a transition screen, then it's moving on to a next series of questions. So I don't want people to think I edited this in a way that is deceptive.
Yeah, there were just in Brian's defense, there were like 30-minute sidebars.
Yeah,
and
right.
a lot of that. So yeah.
All right, and just for the audience and for the record, this is now going to be at 1 1/4 speed, and then at the next pause, if we want to go faster, let me know, and I'll move it to 1 1/2.
Okay.
You're going through the conversation after the Secretary of State that led you to look at the video online.
Yes.
Okay. I want to be clear here. Were you in court on the 19th when we had some preliminary hearings and all that?
This month?
Yeah.
I'm sure I was.
Okay. Do you remember us discussing the fact that the making of a video is not illegal?
I recall some litigation regarding that, yes.
Do you recall that your team conceded that making that video is not illegal?
Your Honor, I'm going to object. It's irrelevant.
What is the
relevance?
relevance?
The evidence.
Well, what is the relevance?
Your Honor, he stated that the making of the video was illegal during his direct examinations.
Okay,
This is cross-examination.
I'm aware that it's cross. Ladies and gentlemen of the jury, the charges are what they are. So you know what the charges are, and you will have further instruction from me as to what the law is relative to those charges. I find that this line of questioning as it relates to whether it's illegal to record the video or make a video is irrelevant. The legality of it is irrelevant to any decision the jury has to make. So,
Your Honor, may we excuse the jury so I can make a record?
no.
Okay, so I thought that was really important. So the judge stopped the defense from being able to articulate that the basis for the investigation was not a crime, and they knew that it was not a crime, or they should have known that it was not a crime. Making that video and posting online, which is what launched this investigation, you'll see later on in that, is not a crime.
Yeah.
The DA should not have been there. The DA investigators should not have been there.
Now, this is the important part, because I'm good with him up to this part so far. Once you learn that it's not a crime, this is the statement you say, and any cop in the chat is going to know I'm right. Well, we kind of talked about this. I don't know if we did it on the record or off the record, but we're talking about, I think it was actually on the record, is, well, the proprietary information, and the create sees expenses and all that other stuff. Okay, fine. That's civil. Go take them to civil court.
Exactly.
And sue them. But just understand there's no criminal thing that's here. Unless you got new evidence for me, I don't see anything criminal. I'm out. Thanks for calling me. And that's
so I think what they're saying, and Alfie, you can say if this, changes things for you in any way. But I think that what they're saying is that taking the video, the state and the judge, is that taking the video wasn't unlawful, but it was in furtherance of an unlawful conspiracy for which she is charged. And so taking the video being the source of them opening a criminal investigation, while it wasn't unlawful, the broader allegations that they were looking at makes it, that's not important because they got to the crimes eventually.
You still got to have something. You still have to have a foundational step. That's a crime.
Right.
You know,
Well,
it's
But
it,
but okay.
if for instance, if somebody comes and tells me, hey, the person that lives in house 123 is selling coke out of there, well, that's good information. That's he's articulating a crime. That gives me enough now to go and I'll go run, you know, surveillance on that house, right? You know, I'll park down and I'll look. And let's just say I spend the whole day there and
Yeah.
there's nothing to support that statement, then it's done. Now if I go and I do that and I see a high volume of foot traffic, you know, that are different people, you know, I see other things that are consistent with drug sales, then I move into, okay, now I can have probable cause, you know, with different, you know, we go and we stop some people leaving there and the people that we stop leaving there have dope, you know what I mean? One of the person says, yeah, I got the dope from that house. Like now I get into the realm of, you know, a search warrant and arrest warrant. But absent those things, just because I know eventually I can get this, well, fine. But I have to have, there has to be something foundational that is a crime that allows.
So that's not the making of the video, but it's what they were asserting is what's on the video. So the making of the video wasn't a crime, but the video captured passwords, which is a whole other thing because the Secretary of State had the passwords, and the Secretary of State is the one that projected the, you know, office is the one that projected them on the screen in the video that was being taken.
In that situation, then I just tell them, okay, show me the statute where it says showing passwords is a crime. And if they show me it,
I'm glad you guys brought this up. I think you should continue playing the video.
Okay.
My office was notified that there was an alleged security breach at the Mesa County voting office regarding that there had been a software upgrade, and there was a video of the software upgrade and posted online. And in addition to the passwords specific to the Mesa County voting machines, those were online, and the Secretary of State was coming to Grand Junction the next day. So they wanted to let me know ahead of time that they were coming in case I wanted to do any type of criminal investigation and be aware that that was coming.
Do you recall that your team conceded that making that video is not illegal?
Your Honor, I'm going to object. It's irrelevant.
What
It's
is the
not
relevance?
relevant.
Well, what is the relevance?
So now that you've done this preliminary triage, what else, if anything, did you do on the 9th of August to kind of learn more information to assist in anything else that you would do as a result of that?
So I began the process to contact Dominion employees to better understand those computers. And even though I'd worked on voter crimes, I had nothing to do with me being in that room or understanding.
I think it's important what the prosecutor asked right there as the first question, you know, that he asked right there. Now that you've done this initial triage. So to me, that is saying that you went in and looked at this and you saw, like, the triage would have to be one of the main foundations of the crime. Like the triage was not a crime. This would be like, you know, triage is a medical term. So this would be, you know, going in and stitching somebody up that was never cut. I don't know. Maybe I'm overlooking that.
So the way I understand this, and it's good that we have all these different experiences to kind of figure out where they're going with this. If I'm triaging something, it means I show up to a crime scene and, okay, maybe there isn't, you know, Penal Code 187 homicide that's there, but I'm triaging to figure out what the crime is. So I'm looking for the elements of a crime. And so if I see blood in the driveway, a shell casing in the road, well, now there's these elements that show me, okay, a crime happened here, probably happened here. There's a high likelihood that there's a crime. That's triaging. But that means that at the end of that triage, if, again, this goes to our conversation we just finished having, at the end of that triage, I either have something that supports a crime happened or I don't. And if I don't, then I either continue to triage if it's available. If not, then I'm done.
Oh, and at the point that this Cannon is testifying here, that not at the point of the trial, but at the point that this happened, right, that he opened the investigation, the assertion in the court of public opinion that, you know, as I think we talked about offline, went for about a year. The assertion was not that a video was made, but that she stole passwords. She stole passwords and she leaked passwords. And that's what the people were told was the substance of this investigation.
Oh, and that comes down to real basic stuff again. Is if you're telling me she stole passwords, okay, then that we do have a cyber crime there. So my next question is does she have permission to be in the facility that housed the passwords? Does she have permission to have access to those passwords? And if
Yes.
the answers to those questions is yes, then there's no crime. It goes to
Yeah,
you know,
she
people-
never had the passwords, by the way. The Secretary of
Yeah.
State's office has those passwords. And the reason that they became accessible in any way is because the Secretary of State projected them on a screen.
Well-
which is violation of password 101, FYI. But
And like I said, and I'm not saying I'm a cyber crime expert. You know what I mean? I'm just going off the basics of these understanding, because we get calls from people all the time where they're just like, my roommate, stole, my, whatever, TV or something from there. It becomes very, you have to have more than that, because, well, does your roommate have a right to live there? Yes. Was a TV in a common room? Yes. Well, it's not theft. You guys have a civil issue that's going on here.
Yeah.
Now, if things are locked up and there's an expectation of privacy and they didn't have access to that threshold of the house, there's different things that happen. So in this situation, if the allegation is, she took information she didn't have permission to, the first one is establishing, did she have any, domain and control of that? And if the answer to that is yes, well, there's no crime there. Give me the next allegation so I can see if the elements are there. And so far from what I'm hearing, it's still all screaming civil.
Yeah.
So here we go. Hit play.
Understanding what I was going to see. So I needed to get a bird's eye view to help structure my search warrant for a judge to get permission for me to go into that room.
And following your attempt to get some information, to get some more background, did you author or write an affidavit in support of a search warrant to search a certain location?
Yes.
And did you apply for a search warrant?
Yes, I did.
Did a judge grant you a search warrant?
Yes.
I want to see that search warrant.
Has indicated that the charges are what the charges are. Is Mr. Hayes or Ms. Peters charged with making a video of the trusted bill?
No.
Okay. Are they charged with releasing the video online from this trusted bill?
Your Honor, I'm going to object as to charges beyond the scope of this indictment. The charges are the charges, just like the counsel said.
Your Honor, I'm not talking about the stipulation. I'm sticking to a probing of a statement that he made on direct examination.
Okay,
Representing
if
this
you would let me make my ruling,
Yes, sir.
the objection on these questions is overruled.
Thank you, sir. So did you misstate and make a mistake when you told the jury that that was an investigation of some illegal activity,
What do you mean exactly?
the making of the video?
Well, in the context, she interrupted me in the middle of my sentence during the interview, so I didn't misstate anything.
Okay. So we also talked in your direct examination about at some point in your investigation, you came across the images were online that were taken from the server.
Yes.
Remember making that statement?
Yes.
Okay. Is there any charge in this case that says Conan or Ms. Peters committed a crime by taking that image?
Objection, continuing objection.
Overruled. You can answer.
I would say in the manner that they were taken, it could be a violation of duty.
You have made to this jury the statement that there were passwords that were put online in the video that you observed. Is that right?
Yes.
Okay. So in those passwords, you were able to link to Mesa County because they were unique.
Yes.
Okay. So I want to explore that for a moment. So let's begin with the fact that you said when you saw the video online, it sounded like it had been altered.
Yes, the voices.
Okay. Do you know if that video was authentic as taken or how it was altered?
Well, the voices were clearly altered in their pitch.
Okay. Do you know whether or not there was any efforts to blur a portion of the passwords?
One of the images I saw did have a blur on a portion of the password.
Do you have any evidence,
Oh no.
speculation, evidence that she knew that that video was going to be released or put online?
Objection beyond the scope of my direct.
The objection sustained is to that and as to relevance, because we've already discussed that it's not a crime that's charged here, the posting of this video or the taking of the same.
All right. Well, thank you, Your Honor. I will move on. Let's talk about the passwords. That's concerning. It's concerning to the jury. It's concerning to me. Were the passwords functional at the time they were on the video?
What do you mean?
I'm asking is, could you look at the video, and even if you had the county's password, were those passwords functional?
Objection, relevance, continuing objection.
This is not something
Can you
we
pause
should
it
hide
for a
from the
second?
jury, Your Honor.
Hold
So-
on. It's almost done. Hold on.
Okay.
I'm sorry.
There are no talking objections.
Yes, sir.
Also calls for expert opinion.
Sustained on that point.
May I make an offer of proof?
No, you have to lay a foundation. How does he know if they're functional or not?
Okay, you're great. Let me lay a foundation, sir. Did you go through the procedures at all that they use at the trusted build, the actual booklet, it's in Discovery as chief investigator, that says the last thing that they do before they sign out of the system?
I've seen it at one point. I couldn't tell you right this second what that last thing is.
Do you know if it's part of their protocol when they are at the very end after the video was taken to change the password
Objection, relevance. Again,
Sustained.
Expert opinion.
Sustained. Both counts.
requires expert opinion.
Okay.
Okay, so they keep dismissing this line of questioning or sustaining the objections on this line of questioning because it's not relevant. But we heard him say his assumption was that it would be a violation of duty, right? She was charged with violation of duty. I won't get into the outcome of that yet. It's a misdemeanor, not a felony, right? But that I don't understand how it's not relevant, because it's directly related to the charges against her, but she wasn't allowed. So her attorneys are trying to show that this direct violation of duty misdemeanor that she's charged on was not in fact a violation of duty. And she's not allowed, her attorneys are not allowed to probe that line of questioning, despite the fact that it's one of the charges. They all said it was irrelevant.
Absolutely. That's not only that, also, this was entirely predicated on the video and the passwords, and neither the video nor the passwords were not only were they not the actual passwords, because they changed them, they were blurred. They redacted the passwords from the video. So yeah, that's why I wanted to highlight on this so much, because the whole foundation of this investigation, in my opinion, now I'm not an expert in any way on this, but the whole thing was garbage.
Yeah, and just so she's in prison for 9 years unless something happens. That's what she was sentenced with. The lion's share of that is the 4 felonies, which are all about the misrepresentation to individuals, right? The 3 people we mentioned, and the conspiracy to do that is the 4 felonies. The violation of duty, official misconduct, and failure to comply with the requirements of the Secretary of State are misdemeanors. There's a maximum for those 3 charges of like 2.5 years prison time and $2,750. So this is minimal stuff, right, compared to what she eventually got. But as Brian said, it was the whole predicate. And they carried the story that Tina Peters stole passwords and threatened our democracy, et cetera, for about a year. It was until, I think, the indictment, when we had clarity on what she was being charged with, that it became very clear that that was not a part of it. Now they can say, well, official misconduct includes what she did with the passwords and everything. But when you go to the extended charges, like go read the indictment, that's not what she was charged with either, because they didn't want to probe this. They didn't want to go into her intent and they were very strict. And we just watched the judge. That's why, we were saying, hang on a second, pause it, because the judge was helping them. The judge was helping them control the guardrails and limiting what the jury was allowed to see, specifically with why she did what she did and how she did what she did. The jury was gatekept from being able to examine the full record. And again, 9 years in prison.
And they manufactured the outrage based on absolute bullshit reporting. And that's the key as well right there, is because nobody knows the true nature of this investigation, what it started on, what it led to. And it's strikingly similar to not just what Alpha went through, but what General Flynn went through. And so many people in this movement have gone through, where they fabricate a crime. They find out that crime is actually nothing, but they found something else. And that's what they did here.
It's, if this is going to be the long drawn out predicate for a crime that we eventually get to, then it's all relevant. The judge doesn't get to say there's no relevance. If this is all being, molded and meshed together to develop eventually what I'm hoping to see is probable cause. Because I tell you what, I've watched these videos and I haven't seen it yet. And to the audience, when we get to the Jerry Wood part, oh my God, did my jaw drop so many times on that. But the other thing,
the probable cause was a tip from the office, though, and James Cannon said that at the beginning.
A tip's not probable cause
from the Secretary of State.
Still not probable cause.
And so the whistleblower in Tina Peters' office calls Secretary of State, says, "Hey, they're doing something with voting machines." And then the Secretary of State reaches out to the investigator, says, "Hey, we're coming out there to look at this. It might be criminal, so you should, be aware that this is happening, etc." And that's how that happened.
Yeah, but not probable cause. It's an inquiry.
Okay.
So, because here's what probable cause would have been. Secretary of State goes out there, they look into the machines, they see that there is a log of a timestamp and a data. Secretary of State goes and looks at their surveillance footage, looks and says, okay, we have people in here. Then they go on to say, are these people employees? Oh, hey, hold on, this person's not an employee, so we have unauthorized access to this facility. Then the Secretary of State.
How is the video itself not probable cause?
Because
The video is of the forum with password.
Probable cause has to be attached to a crime.
right.
If
Okay.
making the video is not a crime, and if the contents that's on the video is not a crime, there's no probable cause. Probable cause has to be attached to a crime. So that's what I'm saying. So if they would have did all these steps and said, hey, we have unauthorized entry, and then in that case, it's like, because you're giving this case to the agent says, okay, like for instance, burglary would be a foundation probable cause. In burglary, people think, oh, it means you're taking something. No, it means you're crossing the threshold to an establishment to commit a felony, and that'll hit it. So if you have someone that doesn't belong there and people are entering that establishment to then do something that is defined by a crime, now you have probable cause. But if you call, like if I'm the agent, I get this call, hey, look, I just got someone from my office I called and said that there's, this and this going on, be like, okay, I'll tag along if something develops. It's an inquiry, since you guys have legal authority to be there, this does kind of give me a leg up, because I don't, I'm essentially getting consent to be here outside of the scope of a search warrant, because you guys have that legal authority. So I'll go and I'll tag along. Now, at that point, a good investigator is going to, once you start to realize, okay, there is a crime here, I'm in that threshold of probable cause, then a good investigative agent is going to be like, all right, everybody pause. We're not going to do anything further. I'm going to get a search warrant, because you don't want to compromise your investigation and be like, well, how much consent did they have? Did the Secretary of State go beyond the scope of what their consent is? In order not to compromise your investigation, you're going to pause everything, get the paper, and then proceed with it. That's the way it would have been done. And I guarantee you that there's detectives or prior detectives that are watching the show that are like, yeah, that's the way I would have done it. In situations where, again, to bring it, and I try to use the simplest thing so people can kind of understand it, with the roommate, right? This roommate stole my stuff, or, this roommate's doing this stuff. Well, the homeowner has consent to allow us into the threshold of that house. So I get into that house. But during the conversation of that, if I'm starting to see that there is a legitimate crime that happened here, before I go into his, the room of his roommate, whether it's free or paid, I'm just going to write paper to be on the safe side, because you don't want to deal with that. Did they have consent? Was there an expectation of privacy? You don't. And like I said, so far, there's no probable cause to a crime yet.
Yeah. I mean, this is so it's, and I live in Colorado, so it sounds very idealistic. The reality is, show me the man and I'll show you the crime.
Yep.
Here. So this James Cannon guy on the stand was the same investigator in my case. Crazy, right? The only witness in the case against me and my co-defendants whatsoever was from Mesa County. Same investigator going after Tina Peters. The investigation was happening, actually sort of concluded, but then shifted into a civil action in August of 2021, same time that the Tina Peters stuff is going on. And it's this core group within the Secretary of State's office, the AG's office, and Mesa County that seems to be the white knights for elections, right? Like any questioning of any elections gets met with this full force of government. So the probable cause to investigate me, and it was allegedly through the records produced through Mesa County and open records request, which by the way were redacted by the Secretary of State, but produced in full by Mesa County, showed that the predicate was a voter called in Mesa County. A voter in Mesa County was visited by a canvasser, called Secretary of State's office. Secretary of State sends it to Cannon, to DA's office, right? Which it ends up with Cannon, because he's the elections investigator guy. And it's, FBI gets involved, U.S. Attorney's Office, FBI, AG's office, all of this thing, and they end it unable to prove any crime. Now, notably, didn't mention us at all. We weren't included, but the state we were a problem for the state, and we were canvassing on the other side of the mountain range, but canvassing nonetheless. And that turned into a five agency federal, state, and local investigation, unable to prove any crime. Now we're in a civil action, and then all of these friends of the Secretary of State sue us for voter intimidation under the KKK Act. So that's the law enforcement apparatus. So when you say like they can't do that, I'm like, are you kidding me? They had an image of passwords on a screen. There's no way they're not opening an investigation with that in Colorado.
I get it. Like I said, and you can probe. He can probe as much as he wants with regards to the password. He can call the IT people. He can do as much probing as he wants. He cannot get a search warrant, and he cannot make an arrest until there is a crime.
Yep.
Yeah. Now he can even go and talk to Tina Peters. And if she wants to consensually give him a statement, she can do that. There's nothing to say, that the cop can't go and investigate the stuff. He absolutely can. You can start an investigation with the most minimal of stuff, just so people understand. You can't violate constitutional rights until you can show that a crime has occurred. It's like, hypothetical situation. It's like I call Florida and say, hey, CanCon's got a meth lab at his house and he's trying to sell me meth. The detective doesn't just get to go, oh, hey, we're writing paper on Can's house. He's gonna tell me, hey, show me a copy of the text messages to verify. There has to be factual information to support that a crime is occurring. That's it. Like I use my case all the time. Allegedly they had a whistleblower that called and reported my social media. Okay, let's just say we believe that for a second. That warrants them to be like, hey, this is kind of spicy. We'll go to his house, knock on his door, and we'll have a conversation. They would have been fully within the scope of their authority to do that. And then when I answer the door, I can be like, go pound sand, I didn't do nothing. Or I can say, yeah, I'll have a conversation with you. And then what happens after that is different. When they went and executed a search warrant on my house with the FBI and flashbangs and all this, there was nothing to support those actions. There was no probable cause to support those actions. It was an illegal act. Ultimately, why they dropped my case. And in this situation, so far from what we've heard, there's nothing that supports a crime has occurred. So you can probe all you want, but there's nothing to support a search warrant or an arrest.
So from a weaponization of government state, because I don't think I realized how important this one detail is until right now when you're saying, there must be evidence of a crime. In my case, when the complaint came in, and again, it's the same people, same time frame as they're persecuting Tina Peters, which is why I think this is, I've always thought that the dark month of August 2021 is very interesting to me in terms of Colorado. When you have the investigator, so CDOS gets a complaint, so it goes out to Mesa County, reached out to Mesa County, says, oh my gosh, there's just, horrible things probably happening. And the investigator says, unable to prove any crime. That's very important, right? Because they've done the investigation. They're unable to prove any crime. So what does it say then when the response of CDOS, the Secretary of State's office, is, well, we need to reach out to the U.S. attorney and the FBI because it might not be a state crime, but maybe it's a federal one?
I would say, I don't think that's unreasonable. If you go through your municipality and your state law enforcement, and they tell you we don't have it here, and you're still adamant that something did, and so you move it to the next level, see if there's a federal crime, I actually I'm okay with that, as long as they follow the same measures. You start off with reasonable suspicion. Does that escalate it into probable cause? And if there's probable cause, then we escalate into paper. And when I say paper, I'm talking a search warrant and arrest warrant.
You're also coming from the local authority being the origination, right? So like you're the cop and you're seeing there's potentially a crime here, and we're kind of getting off base. So we can.
And the reason I'm okay with that is because it happens both ways. A lot of times an investigation will start off at the federal level and they realize we don't have it, but the state does. And so then we get the phone call. And so that's not unreasonable. It's not unreasonable to be like, hey, we don't see a state crime here, but this would apply federally because they, you know, is a crime that crossed state lines, so to speak. So you call your contact, you know, at ATF, DEA, the FBI, whatever the case may be. So it's not unreasonable for that to happen. But regardless, once it lands on whatever, whether it's a cop, a sheriff, or someone on the federal level, they still have to follow, you know, is there a crime? Now, granted, and I'm not a federal agent, you know, their definition of, you know, what's reasonable, what's probable cause, and the leeway they have may be a little bit different. But ultimately, it doesn't matter whether you're state or you're federal. If you don't have probable cause, you don't have paper. That's it.
Okay, let's go. Let's keep going.
I'm a cybersecurity professional. I work for Northrop Grumman. I've had a lot of cybersecurity training. I held the CISSP, which is a Certified Information Systems Professional certification for over 17 years in good standing. I'm also a certified ethical hacker, and I'm also a certified hacking forensic investigator. And I've done everything in the information technology business, from site design to accreditation.
Now, in the video you saw was the partial BIOS password, the password that was on the system before the trusted build was done, or after the trusted build was done and the hard drive had been wiped?
It would have to be before, because it's in the installation process at the very beginning of the steps. So therefore, whatever was seen at the beginning is irrelevant to the end result.
So assume that on May the 25th, 2021, the trusted build was performed. At that time, would the password visible in the CodeMonkeyZ video have been what was on the video? In other words, was it the password that was there before the trusted build?
If the trusted build was done in accordance with the procedures, it would not. And again, the BIOS password was not clearly visible in the video.
All right. Now, assume as a second fact that on August 2nd, the video went viral on the internet, okay? Could a hacker have used what you saw in the CodeMonkeyZ video to cause any harm, interruption of service, or any damage to the Mesa County voting system?
No.
Let's talk about the procedure, not the video. The procedure says that at the end, the BIOS passwords are reset, correct?
Yes, that is correct.
Next thing, the video that you were given was never represented to be all of the videos taken, but the one that was from the Gateway Pundit. Did you review JJ7 from the Gateway Pundit that was sent to you by counsel?
Is that the video, the CodeMonkeyZ evidence video?
Yes, it's called JJ7.
JJ7, yes, I did review it.
Okay. Now, the fact that there is a list of other passwords that were in a screenshot, would that still hold true to your opinion that a defunct password that has been changed at the end of a procedure would render that to have no value?
Judge, I'm going to object to that. He's unable to testify. Yes. He's unable to testify as to when this screenshot was taken. So that's assuming that they're old passwords. That
okay. So the objection is what?
Is relevance and lack of foundation that he is qualified to testify.
Pause it for a second.
That he doesn't have any basis.
All right, give me a moment.
Notice when her attorney in the prior clip, when her attorney objected, the judge yelled and said, no speaking objections. That was in front of the jury, right? Here, Dan Rubenstein makes a speaking objection, gives all the reasoning for it, and the judge asks him to repeat it.
Yep. And remember, they asked them to lay the foundation. They asked them to lay the foundation on an expert witness. Cannon couldn't do it, so they had Clay Parikh and Mark Cook both testify to the procedures that they were supposed to follow, that after the trusted build, the passwords would automatically be changed, as not automatically, but they're required to be changed as part of the procedure. And so even if they did post passwords, which they did not, they were not valid passwords. They were redacted. The other key point here is the attorney says that there were, other videos, but this one specifically, the JJ7 or whatever it was with Ron Watkins, that's the one they're referring to. And Cannon admitted that when he said that the pitch was changed in their voices and all that. Because I think, if I remember correctly, I think Watkins kind of did like the anonymous kind of thing to it, where he was talking with a muffled voice or whatever. So just to be clear, because that's going to be relevant at the end of this clip. Go ahead.
And hang on, just one more thing is that they're talking about the value of the passwords in these expert clips, right? At the end of the trusted build, the passwords have no value. That is a problem for the state because of the benefit harm requirement. And that's where we get to the benefit harm is she wanted to be internet famous on, by being, whatever. So
well, here's the other thing too, to go back to the conversation with Cannon when he was on the stand, and I should have stopped it then, but it was flowing and I didn't want to. When the defense attorney is asking him about the video, and he says, "Well, I don't know. She interrupted me on that part when I'm talking." You guys know what I'm talking about? That's a coached marker, and the reason being is, as an agent, you're doing so much in an investigation. You know, you're not thinking about when someone interrupted you or you didn't, but you could tell that the prosecution had preemptively knew that was going to be a weak spot.
Yep.
And they knew he was going to be questioned on that. And so, you know, because there's certain ways you can show people to help them, remind them. You can't really do coaching, but we know it's coaching, to where I can say with a strong degree of confidence that they said, "Hey, you might want to watch this particular part right here in this conversation." And so then when he goes and reviews it, now it's fresh in his memory. Oh, she interrupted me on that part. So this way, when he's questioned on this cross-examination, that's why his answer was, "Well, she interrupted me." Like he knew that question was coming and he was prepared for that question. And you prepare for the things in the case that you think are going to be important.
Yeah.
And you know they're important because they're highlighted. In that particular situation, that's not important to his investigation, but it would be important to the whole conversation we're having here on the foundation of how this is predicated. So I did catch that when it happened. So if people want to go back and rewind that part, you'll catch it. But here we go.
I think he answered. He answered in the affirmative.
So based on what I see in the video, it looks like there's a couple snapshots, one outside the BIOS and one inside the BIOS. And the BIOS password could certainly be set at any time in this, but according to the procedures, it would be set after this work was done.
Okay. So just
That's
last
the last
question.
thing that's done in the instructions.
Last question. According, if the Secretary of State followed that procedure, the password, if any, that is blurred and depicted in the video would have no value. True or false?
If that is a password that's blurred, it would have zero value if a new password was set according to these procedures.
Can you pause it just one more time? Just want to remind people that during this trial, while all of this was going on, Jenna Griswold had all of the passwords in passwords in several of the 64 counties for over 600 machines posted in a spreadsheet on her website that was just in a hidden tab, no encryption, no password protection, no anything.
And they were active passwords.
And some of them at least were active passwords. Yes.
I did not know that. Wow.
Yes, dude. This is why whenever
story.
anybody talks about Tina Peters on social media, on X and whatnot, Jenna Griswold always comes up, because Jenna Griswold literally did what they alleged Tina Peters did to open this investigation, posting the passwords. And not just for Mesa County, for 62, I think, out of 64 counties.
Yeah, and
active password. So in other words,
some of them were active and some of them had been changed, just to be clear.
Yes.
But it was like the county, the device, the model number of the device, and the password in a spreadsheet.
Yeah.
And what the investigation showed was that it was scratch paper for one of the workers, and they just forgot to remove it. And so no harm, no foul. And then Jenna Griswold and people from her office and Chris Beal, who was mentioned. There's when this happened, you have a whole bunch of interviews and a trial, by the way, because the Libertarian Party sued over this and went to hearing, not trial, but hearing, and live tweeted that. But you have them make all of the arguments that Mark Cook and Clay Parikh are making about how these passwords aren't a super big deal. Jenna Griswold's office is making those arguments when it's Jenna Griswold's office that is responsible for the breach of passwords, which at the time that they're making the opposite of arguments in this trial, those passwords were active on the Secretary of State website.
I make reference to that a couple times in this video, I believe, with these little intermissions that I put up. But to be honest with you, we should have brought that up earlier, because I thought that was kind of common knowledge amongst, especially, truthers like us. But yeah, Jenna Griswold did exactly the same thing. Well, no, not exactly. Way worse than what way worse than what Tina Peters is accused of doing.
And then when caught, tried to cover it up, got called out by the Colorado GOP because they had a whistleblower.
They had Democrat clerks calling her out.
they have Chris Beal of the Secretary of State's office called Josh Zegelbaum, or I don't know who called who, but there's a recording of a conversation with Adams County Clerk Josh Zegelbaum, where Josh is basically saying, like, what is this? How I'm in Adams County, my passwords, I'm paraphrasing, kind of summarizing, right? My passwords, some of my passwords are in that spreadsheet. Like, how do we know there's no breach? How do we know? And Chris Beal is basically saying, well, we weren't going to tell the clerks because there would be a media storm. There would be a media storm about it if we tell the clerks. So they came out and they said, oh, it's already been mitigated. There was no breach. It's fine. Most of these passwords weren't even active. The problem with that is they never talk to the clerks, and the clerks have the equipment. So they can't confirm that everything is fine if they haven't told the clerks, but they were hiding it from the clerks.
Yes.
And then they appointed their own investigator, did their own investigation, said the scratch paper thing, and everything's fine. And it's totally different because Jenna Griswold's office is good and Tina Peters' office is bad. Yep. That's the key takeaway from the entire freaking saga, where these people investigate themselves and find no wrongdoing.
That is wild. All right, here we go.
So the video that you were sent may be a different video than a version of the video that had the passwords on it. Is that correct?
I see no passwords in this video.
Okay. Well, thank you. I will move on to a different topic because it appears you.
What's that?
Key moment. No. Back it up like 5 seconds.
Okay. Well, thank you. I will move on to a different topic because it appears you did not necessarily see the video that launched the investigation.
That was the video that launched the investigation.
You did not see anything in your video that is potentially passwords at all.
That's correct. I watched this video probably 20 times. I don't see a single thing that could be a password.
Okay.
I'm not able to read any password in this. I don't see anything that even looks like a password in this video.
Okay. Thank you. So you would not have any ability to tell on the video that does have passwords on it whether that was taken at the beginning or at the end.
I have no idea what video you're referring to. I've only seen this video and I see no passwords in it.
So let's say hypothetically there was a video that was online that had passwords on it, which was partially blocked out with a black bar.
How is not objecting to this?
Yeah.
How is the defense not objecting to this? Hypothetically, there's a video that has no. You fucking show that,
and it was never shown to the jury. Right?
It was never shown to the jury. Hypothetically, what if there was a crime that was committed? What? All right.
The video was never shown to the jury.
The one that they claim had passwords, because to Brian's point, it doesn't exist.
It doesn't exist.
Yeah.
Cannon even acknowledged the video that predicated this was the video with the changed, altered voices and all that stuff.
Code Monkey one, yeah.
The Code Monkey one. Gateway Pundit posted that, and I still believe to this day Gateway Pundit has that video up. I wasn't writing for them at the time, so I don't know for sure.
So this hypothetical video has never been shown.
No.
And importantly, was definitely not shown to the jury.
And now he's posturing to the jury. What if this hypothetical video did exist? Like, no, that's not. It's irrelevant. It's completely irrelevant. And not only that, it biases the jury right now. The jury is now hearing that, well, maybe it does exist. You're altering their thought process on this. This is manipulation right here.
Yeah, that's the key, because when the defense asks questions about the origin of the video, the what about this, the inception of the case, the judge says it's not relevant.
Yep.
The judge overrules those objections based on relevance. But here, Dan Rubenstein is saying, hypothetically, what if this video that launched our investigation did have passwords in it, after he's already said the video that launched the investigation, Cannon video that launched the investigation, is the one with the blurring of the whatevers and the manipulated voices. So the judge is fine with this. The judge is allowing this, but when the defense, again, rights of the accused are first. This is a criminal freaking trial in front of a jury. The rights of you are innocent until proven guilty. She was not innocent until proven guilty. She was guilty before the trial started.
See, and I'm not an attorney, but my understanding here is, one, the defense should have objected. He should have objected relevance. The prosecutor would have said, hey, and defense should have called for a sidebar. They would have approached and he would have said, hey, if they're going to produce this video ultimately, then okay, we're good here with this hypothetical. because you are allowed hypotheticals in the court of law, because you're moving down something that's going to be presented later anyways. There's evidence to support this. So like, that's why I'm saying, if the video is going to be shown, then I can see why the judge would allow it. But if he didn't object, he should have objected.
In hindsight, we know it wasn't shown. So to be fair there.
Yeah.
But still, it's, even if it was going to be shown, the defense is still going to know about it because it's going to be in discovery. It's going to be an evidence item.
Also, I believe this was Tina Peters' case here. So the prosecution already had their opportunity to present that.
This is Dan Rubenstein speaking.
Yeah, but this is cross, I believe.
I'm
pretty sure.
Yeah, I think that's right.
Tina Peters brought Mark Cook as the expert witness, and Rubenstein's case has already been rested. So
yeah.
if they didn't introduce that hypothetical video talking about it in retrospect, like in or not retrospect, but talking about it after the fact, is completely and totally.
It still changes. You can add a variable, but still you do the sidebar, because then the prosecution is going to be like, well, we had the video and we're going to use it to impeach the witness. And then you can move forward with the hypothetical. But that means, because you're going to introduce this as evidence, you're going to bring it forward.
Yeah. So you remember how I said that, we started out, I'm not going to start out with the judge is corrupt and the system isn't fair. I'm still not going to. But by midpoint, right? Like around midpoint, you start to see these things where the judge is putting his thumb on the scale in subtle ways in front of the jury, right? So ways like, that's not relevant, overruled, you can't talk about that, no speaking objections, yelling at the attorneys very angrily, right? This is all happening in front of the jury. And then when the prosecution is up there, it's, the speaking objection is fine. Let's explore this more. There's no yelling. There's no, those kinds of things in front of the jury. And I'm not even talking about the specific guardrails, like the relevance decisions and things that absolutely manipulated what the jury was able to see. I'm talking about the conduct of the judge in front of the jury, which there are several from about the midpoint to the end of the trial. And then we saw the truth about this judge in the sentencing on October 3rd. But there are subtle things where he's, in my opinion, putting his thumb on the scale in front of the jury, so the jury gets a sense that the judge is on the one side. And that's a big problem in a jury trial, because no matter how hard you try to make the jury the fact finder, the orientation of the jury is still going to defer to the judge. The judge still has a lot of sway and a lot of pull with the jury, because he's the authority. Even though technically they're the authority in the courtroom, the judge is the authority to the jury. So the judge showing open bias, showing favoritism, no matter how subtle, to one side versus the other, is a real problem in a jury trial.
It is. And just so the jury understands, and either one of you can add to this, like I said, I'm not a lawyer. When we're seeing speaking objections, or the judge saying speaking objections, that means the person that's objecting is going to be like objection relevance, or objection asked and answered, or something to that. The judge will make the inquiry if he wants to in both of them.
Up at the sidebar usually.
Yeah, that's what I'm saying. Or he'll typically just call them to the sidebar and they'll address it there. It's not objection with a narrative behind it. And so just so everybody understands what that is.
And the reason for that is because it can be, those speaking objections can taint the jury. They can introduce things that's not in evidence. There can, a crafty attorney can do through speaking objections sway the mind of the jury. And that's why it's limited. You can say the reason for the objection, if we're going to talk about it, we're going to talk about it at the sidebar. All of the trials that I've seen, bench and jury trials, have been this way. Even like the bench trials where there is no jury, so there's really no risk of it. You don't want to taint the audience, right? The gallery, or the whatever. So it's very unusual to allow the speaking objections in open court in front of a jury, but apparently for Mesa County DA, it's fine.
All right, here we go.
Partial passwords of somebody be of value if they were active passwords.
If there was hypothetically something with partial passwords, no, partial passwords don't let you into the system.
Okay, so a cyber criminal
You have the entire password.
So a cyber criminal who's trying to hack into a system would never benefit at all from a partial password. They couldn't do things to try to figure out what the rest of the password was.
Two sets of passwords.
There may be things people could try, but without having the full password, you're not going to be able to get into that system.
And if it's blurred out enough that you could tell, for example, the length of the password, that might be useful.
It's hard to say. I don't break into systems, but I do know that if you don't have the password, even if you're one character off, a single character off, it will not let you into the system.
Okay, but having
Passwords
the numbers, the number of numbers versus letters, that might be useful.
I couldn't speak to that. I don't hack into networks.
Okay.
I don't crack passwords.
And you would agree that if a
See, there should have been objections here.
Yeah.
Well, I mean, I think at this point, the desperation of Rubenstein and the prosecution was so glaringly obvious. Like, not because, you know, he brings up the hypothetical video, and then his probing after that is, well, what if you knew how many characters were in the password?
Yeah, but
does that make it easier? It's like, what?
It's still, it should have at least been to disrupt, you know, because again, the jury needs to hear a judge, you know, spanking down the attorney. You should objection asked and answered. And then the judge would have told Ruben.
It is relevant. You can't do relevance on this, because this was an important moment. I've mentioned it a couple times, but I want to make sure it's really clear. This is the benefit harm theory, right? So on some of these charges, the value, the passwords being a thing of value was important to their ability to convict. Now later, they shift it to internet fame. Right. And it's towards the end of the trial, the judge explicitly asks them, not in front of the jury, but behind, when they're, you know, doing the, I think it was the jury instructions. The benefit harm theory is explicitly asked, and they go internet fame. I think because they can't say passwords, because the value of the passwords was thoroughly disputed in the trial by the witnesses, and they couldn't make their case then. So they shifted it towards the end, in my opinion.
It's because it's very powerful when a judge rubber stamps a statement from a witness, and if the defense here would have said objection asked and answered, the judge more likely statement would have been like, the expert witness already testified that without the expert that there's no value. So, and then he would have told the prosecutor, so clarify your answer if he's going to allow him to go forward with it. But it's important because then the jury hears the judge saying that the expert witness already said there's no value if you don't have the whole password. It's like it cements that opinion. Even though it's still just an expert opinion, it's still cemented because you have the judge doubling down on it. And it should have been used there. But here we go with play.
Video is posted that does have passwords that are blurred out, it is likely that at some point that video was taken before the passwords were blurred out and somebody was in possession of the unblurred passwords, right?
Okay, there's a lot of hypotheticals. Can you repeat that?
Yes, you would agree that if there was a video posted that did have passwords that were blurred out, it's likely that at some point prior to it being blurred out, somebody was in possession of unblurred passwords.
If someone had blurred a video, then there's probably a time that the video was not blurred. I could say that.
Yeah, I'm with Alpha.
According-
Where are the objections?
If the Secretary of State followed that procedure, the password, if any, that is blurred and depicted in the video would have no value. True or false?
If that is a password that's blurred, it would have zero value if a new password was set according to these procedures.
I think that's the end of the video. Yeah.
Yes.
On that one, he should have objected to calls for speculation.
Yeah.
And then if the judge doesn't give you the win, then you clean it up on, when you cross, when now you move into your cross. But there's a lot of objections that were missed by the defense.
Yeah.
That shouldn't have been missed.
Well, so the whole point in me putting that together, again, Ash and I live streamed every single day of this trial together. I think there was like a couple days.
We missed the opening statements.
Yeah. And there was like a couple hours where like Ash was doing something or I was doing something, but one of us was always in the background watching it, listening to it. The problem is you don't catch all these things in real time, and you're streaming 5 or 6 hours before you do any discussion, and things slip your mind. So, I had started doing this just because there was one specific clip that I wanted, and in searching for it, I found all these other little things that kind of I felt like I needed to highlight them. And I said this when I posted it. The one thing that pisses me off about this is I didn't do it right away. I should have done this a year ago. And it took me a year to put this all together. And that really pissed me off. But, I think, anybody that with a shred of common sense looks at this and realizes that they went after Tina Peters for the threat that she was to them, and not because she actually committed a crime here.
Well, and again, we started this by reading the charges. This is the reason that this was allowed was to speak to her intent, but she was not allowed to speak to her intent. She was not allowed to talk about why and how and the factors and criteria that went into what she did and why she did it. The state was allowed to, talk about her intent, apply intent to her. The judge was, putting his finger, in my opinion, on the scale in favor of the state. It's also important to realize that and this is the part where you guys cut me off like an hour and a half ago. Oh shit, it just flew out of my head.
While you're trying to gather that
no, I got it. The evidence that convicted, so the misrepresentation of the credentials of the person that took the images, and the Tina Peters took the video. That was another detail. These were stipulated, meaning that both parties agreed to the fact in question, so it did not need to be explored at trial. Tina's, I think, defense was intended to explore the why of it, right? So it was not a question that Conan Hayes was Jerry Woods. That was a stipulated detail in this trial. They did not have to prove it. It was stipulated. It wasn't a question that Tina Peters took that video. Stipulated. This was a show trial. And it was intended to say, oh man, she was convicted by a jury of her peers. But as we've watched and watching the whole trial, you really see it, especially after the midpoint. It was a show in front of the jury, and they didn't really have any opportunity except to convict. They could have nullified the jury. It could have had jury nullification, but then that judge probably would have put them all in jail. But that's really the only way they could have gone, because the details to convict and the way that they constructed this case, all that discussion about password, none of these charges are about passwords.
Right.
None of them. That was all about her intent and insane.
To me, this was like your case Alpha, Fruit of the Poison Tree, right? The whole FBI raid on your place, which ended up leading to state charges, that raid never should have been justified. In this case here, not only do you have, and in my opinion, again, I'm not an attorney, but in my opinion, not only do you have Fruit of the Poison Tree here, but you have a judge that literally took the fruit, wouldn't let them determine whether or not it was poisonous, and put it on the table to serve to its guests. Like that's what happened here. Is this judge would not let them go far enough to show that video was never a crime. It wasn't even. It's not even something that an investigator with a shred of decency would have looked at and said, yes, this is a crime or potentially a crime. Let me keep going. He knew right away that this was not a crime.
Yeah.
And this next video is just
this next one is insane.
This was just crazy. So
Are we doing that now?
Yeah. All right. So now that we're back, let's get into the second video, which is the one that has some more jaw-dropping stuff. So let me bring this up on. And again, you guys let me know when you want me to pause it. Here we go.
Well, actually, maybe we should just lay the foundation on this real quick.
Set it up.
Yeah.
This is the whole thing. This is
Well, so in addition to the manufactured outrage that we saw that Ash was kind of referring to earlier on, this was what everybody was told, is that Tina Peters stole somebody's identity in order to access the room, get Conan Hayes into the room. The man that they alleged had his identity stolen was this guy, Gerald Wood here. And this is how this all unfolds. So there we go.
All right, here we go.
I want to get back to May 2021.
Mm-hmm.
Let's talk about the weekend beginning on Sunday, May 23rd, 2021, a Sunday.
Yes.
Do you have a memory of that particular Sunday of May 23rd, 2021?
I do.
What is memorable about that particular Sunday 3 years ago?
It was a special day at our church. We had outdoor services, and we were there for all of the morning and into the mid-afternoon. And when we cleaned up, and we also at our house that evening hosted a dual graduation party for my oldest daughter and our son, who both graduated.
Were you in the city of Grand Junction at all that day?
No.
And to be clear, were you in and around the Mesa County Clerk and Recorder's Office that Sunday?
I was not.
Between the time you saw Tina Peters and that Sunday, did she communicate with you at all?
No.
Did anybody acting on her behalf reach out to you between the day you gave the badge to Miss Knisely and that Sunday, the 23rd of May?
No.
Let's focus on now between the time period between your children's graduation party, the outdoor church celebration, you working from home on the 25th of May, throughout the summer of 2021, moving into August of 2021. Do you see the time period I'm talking about?
I do.
During that time period, did you have any interaction with Sharona Bishop between the end of May and the first to middle part of August 2021?
There probably were. I don't remember any specific ones. I don't think they were of any significance.
What about with the defendant, Tina Peters?
Again, probably nothing of significance, probably related to Stand, and she may have come and gone to a couple of the meetings. I don't know.
It's important.
You want to speed it up like
Yeah.
you did the other one? I think that was
The
okay.
immunity agreement that was entered into with the assistance of your lawyer and the DA's office, did you receive full transactional immunity, meaning you could not be prosecuted at all? Or did you only receive limited use immunity, meaning your statements could not be used against you?
I only received a limited immunity.
Okay, so was your understanding, sir, that you still could be criminally prosecuted by the district attorney?
Yes.
And furthermore, if you were dishonest and you were testifying under oath and you were dishonest, you could be prosecuted for what crime?
For perjury, for whatever was related that I was lying about, I guess.
And if you're dishonest today, is that still in effect?
Yes, it is.
At any point in time leading up to May 25th, 2021, did you give any permission to have your identity used for unlawful purposes or for any purpose? Did you give Tina Peters that authority, that permission?
I assume you mean be used by someone else.
Yes.
No, I did not.
Did
Pause
you
it for a
give her
second.
your consent to have your identity?
Just a detail that's, relevant. He mentioned there was a special event at our church, right? He and his wife are pastors. Proceed.
Wait. One other thing is, I think it was during Cannon's investigation, examination, when they brought up, is it illegal to use somebody else's key card to access this? And they used kind of the example that what if you go into a hotel room, like when we were at one of the Garts, Alpha, and you gave me your key and said, go in my room and grab my truck keys. They're right here. And so I go and do that. And Cannon said that wouldn't be illegal. So in other words, if Gerald, what they're trying to establish here is that nobody knew that, or Gerald Wood did not know his key card was going to be used to access it. But if he had known that it was going to be used to access it, it might not be illegal.
Yeah, his testimony is that he was hired to do a technical security job,
Right.
an IT job in the Mesa County. And then he went and he got his badge made. And then it was weird. They asked for it back. And then I didn't hear anything again. That's his testimony.
And that's why, and I know this probably gets frustrating for the audience, but elements to crimes are important because the example you brought up, Ken, I gave you the key card to go to my room to get my truck keys to use the truck. And let's say when you go in there, you see my laptop and you're like, oh, that's a nice laptop. And you grab that laptop and you take it with you, right?
No.
Well, I got eyes everywhere. Well, in any other circumstance, you'd be, it's burglary. You enter the threshold of someone's, living space, home, whatever you want to call it, to commit a theft. So that's a felony. However, I gave you the access to go into my room. So burglary is not met in that element. Theft, I could get petty theft, or depending what state you are, grand theft applies,
Right.
but you wouldn't have burglary. And that's what I'm saying. There's a lot of things that, when I'm listening to this stuff, I'm like, where's that felony?
This one gets spicy. This one.
And
gets
why is this so important? Well, this guy's testimony is the foundation of 3 of the felonies she was charged with. 7 felonies, 3 misdemeanors are the substance of this trial. And 3 of the felonies, conspiracy to commit criminal impersonation is felony 6, criminal impersonation felony 6, and identity theft felony 4. That's directly related to this guy's story.
And this story falls apart.
And this was the biggest.
Oh,
This
you're
was
jumping
the
ahead.
This was the biggest talking point in the media leading up to the arrest of of Tina Peters was that she stole someone's identity to break in and do this crime, quote unquote crime. This is
and the premeditation, right? The conspiracy to do it. Because it's like, oh, I was just showing up to do a job. I was, they hired me to do a job.
Yes. All right, keep going.
So real quick before I go, I was not aware, Ash, that he's a pastor. and because this is, I've seen this video already. Knowing that
I don't think I knew it before the trial, but he said it in trial.
This just makes it hit so much harder for me now watching it. So let's here we go.
Be used by somebody else.
I did not.
Did you give it any permission to Belinda Knisley for your identity to be used by somebody else?
No, I did not.
Or Sandy Brown?
No.
And in 2021, were you using Signal on that cell phone number?
I was.
And within Signal, did you can give yourself a custom name, true?
Yes.
And in 2021, did you use the handle Trebuchet?
I have used that name. I don't recall if that was my Signal handle.
Have you looked at the exhibit?
I have.
Does it have your phone number on it?
It does.
Does it have your Signal handle, Trebuchet?
Yes.
Does it have the date of May 13, 2021 on it?
I don't see a date on it.
Yeah, it's right below Tech Team at the top left.
He's got to be
Couldn't
sweating.
see it in the angle. May 13th, 2021. Yes.
Yes. And that is about the time that you testified that you first heard or first talked to Sharona Bishop and Tina Peters about helping them with computer software and technical assistance.
It would have been about that time. Yes.
Yes. Mr. Wood, you can identify Exhibit A008 as part of a text thread that you were a member of on Signal with Tina Peters and Sharona Bishop. True?
I don't know. I don't have any recollection of that.
You acknowledged that you were a member of the Tech Team chat group on Signal. True?
I thought I acknowledged that it appears that way from what I'm seeing.
Yes. And you have no recollection of participating in such a group?
I don't.
Once again, is your phone number 719?
I'm going to object. Lack of foundation, irrelevant, has not been authenticated, and he's testifying.
It's been asked and answered.
You're looking at exhibit number A007. True?
It does say A007.
And again, at the top, it says Tech Team.
It does.
Your Honor, again, I'm going to object. If he wants
Can
to lay the
we
foundation,
have counsel approach? Let's have.
Defendant's Exhibit 001, pages 1 through 9.
Yes,
Have you now looked at all the pages?
I have.
Can you identify Exhibit A as the Tech Team chat on Signal between yourself as Trebuchet, Tina Peters, the clerk and recorder, and Sharona Bishop?
I can say that you have what looks like screenshots of it. I don't know. I don't recall any of this.
Well, what do you mean screenshots of it?
You have screenshots of text messages that you are claiming are between us. Is this not a screenshot?
He's drowning.
I don't know. I'm not a software engineer, but
All right.
if you say so, I'll take your word.
I don't think that's a technical term.
Okay, I don't know. Is that a screenshot?
I guess the question is that, can you identify that as a communication that you had with those people identified in the exhibit? Do you know if you were a party to that conversation?
I don't recall this conversation.
Okay.
And he's a pastor.
Yep.
Thank you.
Any questions for this witness from the jury? Doesn't look like any. All right, Mr. Wood, it sounds like you may be subject to recall. So thank you very much for your testimony here today. Thank you. Free to go, sir.
no. Is he under your subpoena? No.
I asked the court.
Your Honor, we're asking that he be released from his subpoena. He's not under defense subpoena.
Well, okay, you're released from the people's subpoena if you're not under.
Thank you.
So you can't sue him.
Yeah, the attorney can't. Okay, you're free to go. Have a good rest of your day.
I'm serving you a subpoena.
Your Honor, I'd ask the court to make a record regarding this attempted service, which is improper.
I'm over 18, Your Honor. I can serve.
Mr. Wood. I forgot about that.
I'm aware you're over 18.
They're handing this to you, sir.
All right. You can
He
argue whether
disappeared. They were not
Easy,
able to bring him
everyone,
back.
please.
Hold on.
So, do we have another witness, Mr.
Yes,
Spiro?
we are. We're ready to call Stephanie.
All right. So the judge didn't act inappropriately there. It actually is Colorado law that you cannot serve a subpoena if you're the attorney. His staff could have. His staff could have served that. Anybody else other than the attorney could have served that subpoena. So there's nothing wrong in Wood refusing to accept that subpoena. However, like Ash said, the guy disappeared completely for the rest of the trial, only to show up when the verdict was being read.
Well, and not to mention that if the defense team knew that they were going to be approaching this, they should have secured him with a subpoena prior to the trial.
100. Now, the only thing I could think of, and again, this is well outside of not being an attorney, is maybe it was a strategy play. Like if they would have subpoenaed him, maybe it would have triggered something in his memory. And I use that term loosely because there's no way in hell he forgot about that conversation. There's no way. There's no way.
Do you have in this what was in that conversation?
Yes.
Okay.
Yes.
All right.
Yeah. Let's keep going.
Then on May the 19th, the next day, did you send a message to the group?
Yes, I did. I'm asking Clerk Peters if there's anything else Jerry should be doing. Is there anything Jerry needs to be doing?
And what did you mean by that?
To be ready to have all of his stuff done so that when the guest gets there, he's ready to go.
Right. So what was the understanding that you had with Mr. Wood about when the guest arrives, he would be ready to go?
The understanding is that the tech expert would be using Jerry Wood's key. That was the understanding.
And was Mr. Wood okay with that?
Yes, he was.
Did he ever say, no, I'm not going to do that?
No, he did not.
Did he ask you to find somebody else?
No, he did not.
And then when you asked this question of the group, who responded right away?
Jerry Wood responds right away, saying he's going in today at 2 to get computer access set up. Then he goes on to say, I believe we're all set, except that Tina is still waiting for my background check to come through.
And did you respond to that?
I said, fantastic.
And then did you get a message back from Mr. Wood? Oh, I'm sorry. Did you get a message from Clerk Peters?
Yes, Clerk Peters responds that his background check is approved and nice to meet Jerry.
Do you know if they met in person on May the 19th?
I'm not clear about that.
And did Mr. Wood respond 1 minute later to the message from Clerk Peters?
Yes, he did. He said, awesome. I thought it would be, but it's good to have the confirmation.
Okay, I thought it would be. Do you know what it refers to?
I assume he's talking about the background check being approved.
I'm going to object speculation.
The objection's overruled.
On May 24, 2021, did you text or make a phone call?
So it's not a phone call. It's just a voice recording. You just hold the button down and record a message instead of typing it in.
All right. And so that was to the same group,
Mm-hmm. Yes,
Mr. Wood and Clerk Peters?
Yes.
And can we get the response to that, please?
Yes. The response is from Jerry Wood. Hi, Sharona. I was glad to help out. I do hope the effort proved fruitful. I'm available tomorrow evening after, say, 5 o'clock. I generally have a meeting at work that can end anywhere between 4 and 5. Sorry for misspelling your name.
So what effort did you understand Mr. Wood was referring to?
The effort of securing forensic images from the Dominion voting machines.
And when had that been done?
That had been, I apologize, I'm not always right on the dates because it's been 3 years and a lot has gone on. But I believe that the image had been made on the 24th. I believe that's correct.
Is it possible it was done on the 23rd?
It is very possible. Yes.
All right. Now, when Mr. Wood said, I hope the effort proved fruitful, I'm available tomorrow evening after, say, 5. Did he ever say to you, I don't know what you're talking about. I'm not part of this group. I have no idea what's going on.
No, we were very much in alignment with what was going on, and he was excited to be a part of it. And he's checking in, and he's letting me know that he was happy to be a part of it.
This is all speculation.
Overruled.
How did you respond to his message?
I said things are looking good.
What did you intend to communicate by that?
That the initial image, I believe, again, it's been 3 years, but I believe I'm saying that the image was done. The first image was created. That would be what I would be talking about on the 24th.
And what was his response to that?
Awesome.
Again, he didn't say, I don't know what you're talking about.
No.
Objection leading.
Sustained.
So What was your understanding of the purpose of a forensic image of the server?
My understanding of this was it would take a snapshot prior to the trusted build that was going to be performed on the Dominion voting machines, and then another snapshot after the trusted build was over, and then you would take the two images and simply compare them.
And what would be shown by the comparison?
A loss of information.
I'm going to object regarding technical competence or lack thereof.
Sustained.
Okay, what was your understanding of what you would get from a comparison of the two images, understanding you're not a computer expert?
Yeah, my understanding
I'm
is
going to object. This is all dealt in the pretrial litigation.
Sustained.
Yeah, so when they said that when he said I don't remember having any significant conversation, I can't imagine that you forget about the conversation of doing this 007, which is ironic that evidence code was A007, but you're doing some James Bond kind of thing to get a security key card, going through a background check and all that stuff. And then once it's all successful, you're like, awesome, let me know if I can be there to help. You're wanting to help. Right. He was at the symposium as one of the cyber experts. We'll show more later on, but this is like the dream for somebody that was in alignment with the stolen election movement. There's no way he forgot about this. There's no possible way.
I agree.
Exhibit A, the one where we went through where Gerald Wood.
Here's where it gets really spicy.
Inquiring about the backing up of the image while he's at his alibi party. Have you seen that one before?
Are you referring to the exhibit that Wood did not believe that he had seen?
Yes.
Okay. And what's the question?
When did you see that first time?
During trial.
Okay.
So, yeah, I mean,
first
pause it. The investigators seized all their phones, all their devices, produced the stuff from those phones and devices that they wanted to make their case. This was never produced.
Yep. Now wait, just keep going. Don't let this play out. This is a story here.
This is freaking
This is insane.
Especially because I want to make people very clear. I have experience with Celebrate. I've used it in investigations. So here we go.
During trial.
Okay. So during your thorough investigation of this case, you seized a lot of phones, correct?
Yes.
And you had cooperation from Belinda, correct?
Eventually.
And you had cooperation before trial from Sandra Brown, correct?
Before trial, yes.
And you had cooperation from Gerald Wood before trial, correct?
Yes.
And in those cooperations, those two exhibits that you said you weren't seen before, of which they were participants in, they never shared that with you, did they?
Correct.
All right. And their immunity, their use immunity agreement does not cover them if they lie, correct?
Correct. To be clear, Wood had the use agreement. The other two were proffers.
Okay, those were proffers. You heard, and we've gone through this, the testimony that you that the case was put on. Would you agree that Sandy Brown, when she testified, contradicts what is in that exhibit?
I don't know if I'd agree with that.
Okay. How about Belinda Nisley? Is she contradicted by what's in that exhibit?
I don't know if I'd agree with that statement.
Is Gerald Wood contradicted by what's in Exhibit A?
He said he didn't recall it. I don't think he said anything beyond that.
Okay. So did not Sandra Brown testify to this jury that she had no awareness that an image was going to be produced by a person other than Gerald Wood?
Objection leading.
Sustained.
Did Sandy Brown ever tell you that she was aware that Conan Hayes was going to be present on the 23rd through the 26th?
No, she did not.
Did Belinda Nisley ever tell you that she was aware?
After the fact, yes, but not during the time.
When they testified, they represented that all the way through until August, both of them did, that they were unaware, correct?
Just so I'm clear, unaware of which piece.
Unaware that Conan Hayes was going to be there. That was their testimony.
Yes,
True?
sir. Yes, sir.
I want to talk about the Exhibit A first. That's in front of you.
I don't have it in front of me. I know you're referencing the one that Mr. Wood testified that he was unclear about.
Yes, that's the one. That exhibit, you said you had never seen it prior to.
Correct.
And that exhibit contained conversations between who, from your recollection?
Sharona Bishop, Gerald Wood, Tina Peters, your starters.
And you had phone extractions from Gerald Wood's phone.
Yes.
You had phone extractions from Sharona Bishop's phone.
Correct.
And obviously, we did not have the phone that this was taken off of. You're able to tell that from your investigation and which one was in blue?
Correct.
Okay. But two of the three participants in this conversation, we had their phones and got extractions from.
Correct.
Did you review all of the conversations between the parties as part of your investigation?
Yes.
How long have you been working on this investigation?
3 years as of, I think, today.
Was there actually those phones taken as not actually a state search warrant, but it was actually a federal search warrant, wasn't it?
Yes.
And they did the extractions first and reviewed it?
Yes.
Okay, so that to me was like the holy shit moment right there. So the Mesa County DA did not actually do the initial extractions on these phones. It was done by the feds. And then the feds, I'm assuming that the feds then gave the DA, like, here's our work product. I don't know, but either way, there's no way that they're making the case, or the case to be made would have to be that 2 out of the 3 people whose phones they had went and deleted this series of the text message, the text chain. So either Tina Peters, so the 3 people, Tina Peters, Sharona Bishop, and Gerald Wood, I could see why Gerald Wood would want to make it go away once he's given immunity. I could see that. I can't for the life of me figure out why Tina Peters or Sharona Bishop would delete this from the phone. So, to me, that would suggest that they didn't delete it. So this message somehow got deleted between where the FBI confiscated the phones and where they handed this over back to the Mesa County DA.
I mean, maybe. I have so little faith and trust in anything that this particular group of government officials says, because they lie all the time. That, we didn't see that. We didn't know Trebuchet was lying to us. I think that's bullshit.
Well, no. I'm with you on that. But my point is that somebody is lying here. It's just a matter of, the prisoner's dilemma. Put them both.
My money's on the government.
It's far more sinister though than deleting it, because here's the thing with Bright. Even if you delete it, it's going to recover it. Things that are on your phone, folks, you deleted pictures and videos, we still can recover that stuff.
Digital is forever.
Mm-hmm.
So then it had to have been somewhere,
except for system logs and election machines, though.
So that means that it was either done in a way so that it wasn't extracted, or it was purposely designated not to be extracted, or that part of the Celebrite report was not provided.
And there is, Brian, correct me if I'm wrong in how I phrase this, but several times during this trial, it came up that there was there's a federal investigation too. And so, like, I remember it specifically with Sharona Bishop as she was being sworn in. They were talking about immunity, and the state was like, well, we don't have immunity for you, and you have to be particularly, paraphrasing from memory, but you have to be particularly careful because of the exposure to federal charges.
Well, because again, you got to protect the investigator here. Like in situations where I was investigating an international crime syndicate and I came across evidence during my search warrant, you have the task force that's comprised of state and federal employees. You know what I mean? You have agents, officers, and feds. It's a mix of people on the task force. They would tell me, hey, don't even touch that, we're on our way to pick it up. And then they come, so because it's chain of custody, right? So it's secured with me. We do the chain of custody, gets provided to them. So this way, because everything has to be kept clean for court, and then they take it. And they actually did the extractions and the Celebrites into some of these devices. And so I'm still doing my investigation. So when they give me that report, since I'm not the one that did it, I ask the key question: is this a complete report? And they're going to tell me one of two things. It's yes, it's complete. This is what we have. Or no, there's stuff in here that's redacted for another investigation going on. And I say, okay. And the only reason is I don't need to know that information. It's just so that when I go and testify, or I go before a judge, if I'm doing piggyback warrants or anything, I say that there's more to it, but this is complete to the best of my knowledge. But there's the understanding that I can say there's information here that I'm not privy to or I didn't have access to. And I'm doing that, well, again, to cover my bases, so I don't end up on a Brady list.
Right.
Because then if somebody does a FOIA later, like this conversation right here, well, you're saying that this is you gave us full discovery. Like this is a complete information. You know, this is kind of what we talked about at the front end of the show. Like this is that conversation.
And just for the audience, this was a 10-day trial. I think it was 10, right?
It was like 7 actual days, but it expanded like a Monday through a Wednesday. Yeah.
And then the deliberation and whatnot. This was by far the most explosive part of this trial. This was very unexpected by the government.
So let me ask you this, Alpha, from your experience, what is the likelihood that the possibility that this conversation just got overlooked?
So the
especially their star witness.
Especially keep in mind that this conversation took place in the days immediately before and immediately following. So even if going through the Celebrate and you hit the right search parameter or whatever, which is absurd, Trebuchet, Tina Peters, Sharona Bishop, are you
three of the felonies?
Right? Are you not going through other conversations immediately the day before and the day after, or maybe 3 days? Plus 3 days, minus 3 days before the actual event, just going through other things, seeing if there's any evidence in there?
Yes and no. So, and this kind of varies state to state. In California, we have what's CalAPCA, the California Electronic and Communications Protection Act. I believe it's been a while. But most states have a form of this. And what this means is, especially when it comes to like messaging apps and social media, is I can only investigate to the scope of my investigation. Okay. So let's say, I'm going to go through Trebuchet's social media because I'm looking for conversations between Sharona Bishop or Tina Peters. And so as I'm going through that, there's other conversations there. So I'm going to click on that conversation with someone who's not Sharona or not Tina, but I am very limited on how much into that I can read. And once I establish there's nothing to lead me to these other two people, I'm done. And you do it. Now, the other caveat to that is you have to notify these people as well in some form of fashion. And it's so specific that it even tells you that if it's like, a lot of people use handles and aliases, that if you can't actually determine who the real person is, you have to go as far as putting a documentation out on a public paper, and it even tells you like where and how long it's supposed to be there, that, hey, this account. So at least there's a public notification to that stuff. So in this situation, it doesn't. So yes, to your question in general, but specific to Tina and Sharona, no, because my search query is going to include their names. Right. And when I'm going through the file that Sally Bright creates, I'm going to go in there and I'm going to search Tina Peters. I'm going to search Sharona Bishop. I'm even going to put in search terms that, change the names or, different ways of spelling it. Like it'll be that extensive. So you would come across those conversations. Okay. So,
well, the only other thing I could think of, and we never actually find out what the third device was here, or the device that actually had this on here. And the only thing I could think of is they do make reference and say that their cell phones were part of the search warrant. Well, Signal operates on desktop too. And what if they didn't seize a particular desktop computer and that conversation still existed there in its original form? And, they were able to extract it. The defense was able to extract it from there. Any way you cut this, there's a cover up here.
There is, because anyway, again, to the agent, even if this is the first time he's learning about it on the stand, this is now information that could be criminal or exculpatory. Mm-hmm. Immediately when you leave, guess what you're going to be doing? You're going to be writing a search warrant to Signal saying, hey, I now know this conversation exists and I know these two parties were there. I'm requesting, because obviously I think the assumption here is it's coming from a device that belongs to Tina Peters. So I'm going to write a search warrant to Signal on Tina Peters's content between that time frame. And the reason I'm doing this for two reasons. A, I'm going to prove that this is a fake conversation. The Signal doesn't have any record of this, because I just subpoenaed it. Or I'm going to show that it's authentic. And not only is it authentic, these are the other devices that were the recipients or the senders in this conversation. And then I can compare those, whether it's the IMEI number or the IPs or whatever Signal's using to those phones. you can actually corroborate all this to show its authenticity. Like that should have been done.
Yeah, I think there's no universe in which they didn't know this conversation existed.
Well, Mesa might not have. I
Right.
I do believe that James Cannon genuinely did not know that this conversation existed, but the fact that the feds had the phone first, then that put places
And the
the blame
state, don't let
squarely.
the state off the hook.
Okay,
because
fair enough.
Yeah,
Fair.
because the state, Janet Drake from the AG's office was one of the prosecutors in this trial.
Okay.
And so like there's a cover up, as you said. And just a quick side note, California gets a lot of shit, but California has the best data privacy laws in the nation.
One of the other things. Go ahead.
Point
Go ahead.
California.
Yeah, the only conversation that protects Cannon on this one for not going those extra steps I said is that he called the Fed or whoever the agent was and said, "Hey," and that guy confirmed, "Yes, we do have it. Yes, it's authentic. It's classified, or you're not privy to it because it's tied to another investigation." Then he's covered because he did the overt act of going and searching, and he was told that it's authentic. You know what I mean? Or told that
that's exculpatory, though. The feds then withheld that from Tina in her criminal trial.
And I agree with that.
Or the state.
So here is the one thing, and I told you guys I wanted to kind of pick your brains on this when we got to this point. You know, Ash, you were talking earlier about the federal government can't go in there and take her out of prison or whatnot. I think this very well could rise to that level where you can now pull her out because she's the subject of a federal cover-up. If
That's again, though, that's not whistleblower election fraud. It's whistleblower weaponization of government. And I have never argued that she has she's a material witness to the weaponization. I've never argued that she's not, because I think she is a material witness to the weaponization of government in Colorado. And I think on the screen here, it says the feds conducted the first searches on their phones and the state of Colorado depended on what the feds gave them. I'm not sure we know that exactly. We know that Mesa County relied on what they were given from either the feds or the state of Colorado. But what happened between the feds and the state of Colorado is a black box to us. And I would just like to say that in my case, the emails that were produced by Mesa County that were unredacted were exculpatory for us. That we weren't mentioned at all in their investigation, and their investigation was unable to prove any crime. Mesa County produced them for us after discovery and everything, but it was the state of Colorado that redacted them. And it's important to me to make this real clear that at the time that Tina Peters, the investigation into Tina Peters was going and all of the things were happening, was the same time they were coming after us. It was the same time they were coming after Dallas and Rhonda and Elbert County. It was a portfolio, in my opinion, in the state of Colorado, and collaboration with the feds. And nobody will change my mind on that because of what the Biden feds did in my case. But Mesa County is, potentially their scapegoat-ish.
So my point is you
Or
brought
their
up
beard.
you brought up my point that she's a victim of the weaponization of the government, but this right here is a little bit, well, I mean, it is weaponization, but this is an extenuating circumstance where they literally manufactured or not manufactured. They deleted evidence. They manipulated evidence in a way that was exculpatory. And this is the conundrum, because if you pull her out of state prison in Colorado, where I believe with this, this being public information and the ability to look at there's the potential of a conspiracy here, she's in danger in those prisons.
Yeah, no, I think it's a fair point. But my point is, it's not about election. It's not a whistleblower for election integrity. That's not a case that they can make.
But her bond, her bail during the appeals process was denied. And, again, this is the conundrum. If the DOJ goes and pulls her out, this implicates the feds. This implicates the DOJ. So you'd literally be pulled out by the DOJ that is potentially implicated in this cover up. So I don't know. This is
yeah. I mean, I think there are paths to get Tina out. I think that the weaponization one is strong, and there's a weaponization working group in the ODNI. We know they're investigating specifically weaponization with Tina Peters. What I have reacted to publicly, and I stand by it, is that any testimony about election fraud in Mesa County is hearsay for Tina Peters, because she didn't take the images. She didn't analyze the images. She didn't write the report. She's not going to be certified as a cyber expert because she's not one. So saying that we can declare her a federal whistleblower for election crimes and pull her out of prison and put her, bring her into federal custody, to me, that does not hold up. That is not.
The only thing she'd be able to testify in that is validate where the source of the forensic image came from. She would be the person.
Which you don't need, because it's a part of the public trial. And the bar, Alpha, maybe the lines on this, but the bar to go in there and over, for the feds to go into a state and take a witness, you've got to have real important testimony, I would think, to rise to where a judge is going to sign off on transferring a witness, a whistleblower, material witness for election crimes. There's no testimony that she can provide, admissibly, given the rules of the court, that I would think would rise, that a judge would sign off on that. Now, her being in danger is that's a different argument. It's not an argument that people are making, but it's potentially a valid argument. I've always pushed back on the, election fraud whistleblower, which I think rhetorically we can say that, right? Her taking the images was whistleblowing on what was going on, but she cannot testify as an elections whistleblower because she doesn't have firsthand knowledge of the facts of the election crimes. She knows that Conan took the images. She knows all the different experts that analyze these images. She knows who those or what their findings were. Right. And she rhetorically can speak about all of those things, but it's not personal knowledge. It's not firsthand knowledge of hers. It's hearsay from a rules standpoint in the courts.
So what happens now? Let's hypothetically speaking, what would happen if she was a victim of weaponization of the federal government? How does she protect herself from that? When, again, you're not going to go into, what the DOJ is not going to take custody of her and protect her. Colorado could be implicated in this as well. So they're not there. Like, where would she go if they let her out to ensure her safety while this plays out? Because you have to think of why they would go as far as they did to cover this up. You were talking about,
they're criminals. In my opinion.
Exactly. They're criminals. And if you look at, and we'll get into this in part 2, the technical aspects and what was actually uncovered in all of this stuff, there is a lot of questions, and the judge was not allowing any of these things to make it into a courtroom. And now you see a cover up to try and put her in prison. This was tried in Mesa County, where local news was reporting that all of this stuff was factual. This was the justification for going after Tina Peters. And it turns out it was all bullshit. So I think there is a very good case to get her out of prison to protect her safety. But where does she go?
Yeah,
those are good questions. I do find it hard to get her through the whistleblower.
Yeah, 100%. I'm with you.
Formula. However, and I won't go into the details of this because I don't want to arm them, but I'll tell you guys both offline. You could use her as a witness.
Mm-hmm.
And there's certain things that you could use her as a witness for, and those are things that I'll tell you guys offline. You can force the puzzle piece to fit, but it is kind of, it leaves a lot of gray area in that. But we could talk about that offline.
She's definitely a material witness to the weaponization of government, which is a federal focus right now. And there is, I think that there's a solid case there. What Brian and I are going back and forth about is the assertions that are being made by a bunch of people in the public right now that President Trump is abandoning Tina Peters because he's not declaring her a federal whistleblower on elections and removing her from state custody and bringing her into federal custody. I do not believe that he has the authority to do that. Don't think that it would be lawful if he did do that. I also think that that's a very high bar in terms of getting a judge to sign off on the testimony requiring protection, right? And the testimony of federal election crimes, the testimony that she has to offer in that domain, not weaponization, not any other things, abuse of process, things that that she does have firsthand knowledge to, but for the election stuff, her interaction with what was found in Mesa County, all of those kinds of things is hearsay. Yeah. She has secondhand knowledge, not firsthand knowledge.
We're not going back and forth on that. I agree with you 100% on that. I agree with you on that.
Yeah.
All right, let's keep going.
All right, here we go.
Was there actually those phones taken as not actually a state search warrant, but it was actually a federal search warrant, wasn't it?
Yes.
And they did the extractions first and reviewed it?
Yes.
And as part of a process, because people might have attorneys, they go through and make sure that no privileged communications. So lots of people reviewed all the stuff before it got to us, right?
That's correct.
And they were told
CYA.
or you discussed with them to point out any relevant conversations between any of the parties.
That's correct.
And you also reviewed all relevant conversations between the parties as part of your investigation.
That's correct.
Does this chat appear on any of their phones?
No.
That was cover your ass right there. This is a wide net in the corruption of how this did not appear. It did not appear for you. Rubenstein is the Mesa DA, right? Ash, you're muted. So
yes.
So he's concerned about covering Mesa's ass right there. He's saying, okay, it wasn't you, Cannon, that did this, that let this out. There's a lot of people that looked at this before it made its way to you.
Well, yeah. And this whole thing led to the DA's office having to do a cleanup, because after the Woods thing happened, it appeared that the first part of the direct setting up that all of the identity fraud related charges, it appeared that the state was lying. And so they went into major damage control in the trial. It was wild to watch. Yeah. Unexpected, certainly.
Suggested by your answers that the Exhibit A is not authentic. Have you made that suggestion?
I don't believe I have, sir.
Okay. So do you have any reason to dispute that the Exhibit A and the discussion between Trebuchet, which is Gerald Wood, and the others is not an accurate and complete statement?
I don't know about a statement. It is what it is. It's incomplete in the fact that it doesn't have that 15-second voice message to give context of the statement.
Now, I happen to know somebody that says they have that 15 seconds, but I have not heard it yet. So
in fact, I'm going to approach and show you what's been marked as Exhibit A1. Before we get into that, you mentioned that you had reviewed Celebrite. What is Celebrite?
Celebrite is the extraction software that our computer forensic law enforcement associates and civilians use to take a cell phone device, basically plug in the device, and Celebrite is the software to take the data out of the cell phone, and then it's transferred into a work product that I can then navigate around to investigate, kind of like I spoke to the other day. I can do search words query, like I can type in Wood, I can view images, video, stuff like that.
So I want you to take a look at this, because you just testified a moment ago that the phone of Sharona Bishop was seized and it did not have these conversations on it. You remember testifying to that?
Yes.
Could you take a look at what phone this Exhibit A1 is referencing, the Celebrite? Is this Sharona Bishop's phone?
Not sure that it has that information on it.
Have you had a chance to compare this in any detail to the Exhibit A?
I don't understand the question.
Have you seen this document before?
The other day, yes.
Did you compare the Celebrite extraction to Exhibit A to see if they're the same?
To be clear, I have the Celebrite extraction of Sharona Bishop, and I did not locate this.
Okay. Somebody else ran a Celebrite extraction on Sharona Bishop's phone, and you were provided that, correct?
Yes.
Have you compared the other Celebrite extraction in Exhibit A1 to Exhibit A?
You asked me if I looked at the extraction, or are you talking about Exhibit A1 to what you have in your hand?
I'm asking you if you compared the two, line by line, to make sure it was complete.
As far as the conversation, it appears complete, other than that missing 15 seconds, I suppose.
And the Celebrite extraction has the same question on that 15-minute conversation, which isn't included in the text messages, correct? The audio.
Correct.
So just to be clear here, you did not, you were not the one that authored that report, correct?
A1?
Yeah.
This, my understanding, is an extraction, not a report, but I did not author it.
Okay.
The phone that I referenced was not downloaded. That was part of that conversation in Exhibit A. Do you know where that phone was?
No.
When you conducted your search warrant, did you collect all of the phones that were there?
I believed I did at the time, or that officers there that were directed to did at that time.
And Miss Peters was there with you?
She was there with officers, yes. I've seen the body cam and the footage.
She was asked to produce all of her phones?
Yes.
Pause it. Ash, wasn't there like something about them trying to get an iPad from her at a restaurant or something?
Yeah, that was so the story for it, and I think this was a substance of another case of Tina's, is that when Belinda Knisley, who was a witness for the state in this, or for the county/state/feds in this, when Belinda Knisley was in trial, Tina was recording it, and you're not allowed to record in the courtroom. And that was the substance of the iPad, is that she violated the courtroom rules by recording inside of the courtroom, and they were trying to get that iPad. And that was what happened at the restaurant. And that's where they claimed that she kicked the cop and all that kind of stuff.
All right. You can keep going. I think that's the end of it, I believe. Oh, wait.
Okay.
The court at the bench council, we had stipulated to the admission of Exhibit A1.
All right. Yes, A1 is so admitted. The people did stipulate to its admissibility and its admission.
Thank you.
Any questions for this witness from the jury? Okay, looks like we might have some. So if I could have counsel approach. All right, I have one question from the jury, Mr. Cannon. Is it possible that the phones you took had deleted the conversations in question before you were able to take possession of them?
Yes, it is possible.
All right. So that's the end of it. Alpha, you were just saying that on Celebrate, you can recover deleted stuff.
That's correct.
So is
Only
it like
if you try, though.
I was about to say, is it an extra step you have to go through in order to do that?
The software does it itself. Now, granted, I don't know what the level of encryption is that Signal has to try to thwart, third-party apps, or software like Cellebrite and all that stuff. But you can. There's a lot of stuff that comes when we do a report that's not on the physical. Well, visually, it's not on the physical phone as you see it, but it's still stored. However, the phone does it. Whether it's the hard drive or the back end data for that particular app, whatever the case may be. We find it's the same way we find a lot of these ghost apps where the app looks like one thing but it's actually another thing, and we're able to figure that out when you do these Celebrate reports. But you can still recover it.
So but the bottom line here is that either Sharona Bishop or Tina Peters deleting that conversation specifically right there would have been absurd. It would have been unbelievably absurd for them to delete that.
Even then, you would at a minimum you would have information that Signal existed on that phone.
Well,
So
no,
then-
I'm talking about that specific conversation, not Signal.
but that's where I'm going. It's because you got to remember, these investigators are not rookie cops. You have tenure and experience to get into these into positions, and if you're handling a high profile case, you're probably one of the senior investigators or senior detectives that's there. That's the people that you're not going to give a high profile case to the new guy. No, you're going to give it to someone that has experience. And if you go through the phone and you see, if video game apps are deleted, you're probably not going to go the extra step to make sure that it was a video game app, unless it's like something crazy like a homicide or something. But if you go and you see that there's a messaging app that was there and it's no longer there, and it's a case like this, you're absolutely then going to write a search warrant to that particular company. Whether it's WhatsApp or Signal or Snapchat, you're gonna do a follow-up search warrant to that particular company, where you're gonna learn about this conversation, or at least you're gonna learn the timestamps depending on what the retention policies are for these particular ones. And that's not hard work to do, and it's also basic work to do as an investigator or detective.
So go ahead, Brian.
No, go ahead, because I'm going to kind of change the subject a little
Okay,
bit.
well, I want to put a fine point on this for people. Before we went into the videos, we read the charges, right? 7 felonies, 3 misdemeanors. Tina Peters was acquitted on 3 of the felonies. Those were conspiracy to commit criminal impersonation, and identity theft. The 3 charges, the 3 felonies that she was charged with that Jerry Wood's testimony and his story of having his identity stolen for his credentials, that was, the jury got to reasonable doubt. And that to me is why it's so egregious that she was never allowed to talk about her intent. She was never allowed to talk about, the reasons or the stuff leading up to And this is why she did not testify, by the way, because she wanted very much to tell her side of the story, but the judge straight up told her, you're not going to be allowed to tell your side of the story. And that would open, she'd be opened up to cross-examination on, whatever they covered. But she decided not to testify. But the judge made very clear before she decided not to testify that she would not be allowed to talk about her intent. Had she been able to talk about her intent and why she did what she did, and, the whole actually defend herself, had she been able to actually defend herself, it's quite possible that the jury would have gotten to reasonable doubt on the other charges as well. But they were so gate kept that this one was, and you can tell from the prosecutors and James Cannon on the stand, this was unexpected. This was impeachment evidence, right? So the defense doesn't have to disclose it. They didn't have to tell everybody. I personally think they should have secured the subpoena of Jerry Wood before the trial so that they didn't have this problem, right? Where he ran away and was never able to be recalled, and then showed up again at sentencing, or at the verdict, right? Wasn't it the last day when the verdict was read? Yeah. But the process was so gate kept. What the jury was able to see was so gate kept. And then again, as we talked about at the beginning, when the judge went to sentencing, he relied on all of it. He mentioned all the stuff he personally did not allow to be presented to the jury. He mentioned that stuff in his calculus for the severity of his sentence.
Well, let's go ahead, Brian.
Well, so the point I wanted to make is I wanted to get back specifically to the phone thing right here. And, I've said before that I think there could be something else going on around the whole Tina Peters, like that is an actual distraction, and that there's something else going on a scale that we don't understand necessarily. And to me, this is more evidence of that, because look, either there was like really gross negligence in how this case was handled by the defense, or there's something else. Because like, how do we not know the chain of custody directly? How is that not brought up, the exact chain of custody that this conversation went through? What was the predicate for the warrant? Like and these are things. Okay, so maybe I should not say that this is on the defense, but to me, it wasn't sufficient enough. And I'll call it what it is. But there's a lot of things that I think they could have been far more diligent on getting to this point. And there's a lot of arguments they could have made, like the whole first video that we played here. Like this entire crime was based on getting Tina Peters. It wasn't based on a crime and who committed that crime. It was based on Tina Peters posted this video. Now let's see what we can find from her. And then from there, all the results, the other charges were all like, influencing a political official and like all this other bullshit that never would have happened if it wasn't for the initiation of the investigation based on something that wasn't even a crime in the first place. And so, I look at this and I wonder, there's a lot of things that I wonder about this case and well beyond that case.
Well, there's a lot of things we don't have to wonder, right? Tina Peters is their most important scalp in the state of Colorado, and I would argue one of the most important scalps from an election integrity standpoint nationally. They changed the law based on what they asserted that Tina Peters did. They changed the law in Senate Bill 22-153 right after her indictment. Jenna went to the legislature and was basically like, this is a massive threat to democracy. We need this. All the expert class, the Colorado Clerks Association, they all came on and everybody started handling the legislators, making sure that all the legislators understood just how dangerous this was. And they changed the law. So we said this wasn't a crime. Taking the images wasn't a crime when Tina did it. Dallas did it too. It is a crime now because they changed the law. And the third thing is that it gave them the story. This is why, ties back to the first. This is why she's their most important scalp. Tina Peters' story, that as told by the state, is the underpinning of the danger of the big lie and how election denialism is such a massive threat. Because look at Mesa County. Yep. And all of those things were very important to what they did to us in the years following this trial.
And not only that,
or this indictment,
following her arrest and everything else, she ran for Secretary of State in Colorado, and
won the assembly.
She won the assembly handedly. And we'll get into this more in part 2 because I think this more ties into that
We're probably gonna
aspect
have a
of
part
it.
3 for sure.
Oh yeah, I'm sure we probably could. But so she runs for Secretary of State. She ends up getting primaried by a woman named Pam Anderson and another guy. I can't remember what his name was. He didn't do much of anything.
Oh, I know his name. It's Mike O'Donnell.
There
He's
you
a
go, Mike
foreigner.
O'Donnell. Yeah, he's Australian, isn't he?
Yeah, or New Zealand, one of those.
New Zealand, something like that. So Tina Peters runs against Pam Anderson. Do you know, Alpha, who Pam Anderson is?
Not the Baywatch
Not
one.
the Baywatch babe. He was
Definitely not.
it the executive director of CTCL?
She was, yeah. She was a former clerk. She was the executive director of the Zuckerbucks.
Yeah.
She was also the head of the CCCA before Matt Crane. But my favorite data point about Pam Anderson is that her mother-in-law, Norma Anderson, was the lead plaintiff in the Trump 14th Amendment case to keep President Trump off. And they said this case is brought by Republicans and unaffiliateds and their regime puppets. And so as, you know, Pam Anderson ran and lost. I actually think Pam Anderson might have been worse than Jenna because Pam Anderson actually knows how elections work, you know?
Definitely.
Yeah. But so that was that. And then, you know, 2 years later in the following election, her mother-in-law is suing Jenna Griswold to keep President Trump off the ballot. And of course that went up to the US Supreme Court and was overturned. But it's, I mean, it's, I'm sure, I know it's a coincidence.
And like Ash said, Tina Peters won the assembly pretty handedly. I think she had like 69-70% of the vote.
She didn't, Mike O'Donnell got enough votes to make the ballot too. And that was important. Now that assembly was a shit show. Yep. They flew in and drove in clickers that half of them, well, I can't say half of them, but a lot of them did not work. The instructions, people were told for how you check and make sure that your vote was calculated, that wasn't working. They didn't have enough clickers. There's no chain of custody on the clickers. They were thrown around the arena. There was, clickers everywhere. The whole thing was a farce, and it was a uniparty run assembly. Tina Peters won handily, but Mike O'Donnell got enough votes to make it onto the ballot. So in the primary, and Pam Anderson did not go through assembly. Pam Anderson petitioned on.
Yeah, she got signatures. That's the key. She didn't even go to the assembly to try and make her case. So you have in Colorado, now remember, this is the Republican primary, not the general election. In the Republican primary, you have the head of CTCL, the Zuckerbucks, following the 2020 election when everybody hated the CTCL in the Republican Party for what they did. Even if you didn't like Trump, you didn't like what Zuckerbucks did. And they voted for her, who got on the ballot, didn't even bother going to the assembly, goes and petitions onto the ballot. She somehow beats Tina Peters, who was,
I can tell you.
I don't think she was Trump endorsed, but Trump was in her corner. She was Trump adjacent during this time. And she out fundraised Pam Anderson handedly. And Pam Anderson wins the election.
Well, let's do this because I want to make sure that it's an episode that the audience can swallow because we're approaching that 3.5
Can I just tell the last part of that story and then we can move on? Okay, so the reason that Pam Anderson won the election, the primary election, is because of Mike O'Donnell. Because Mike O'Donnell was a third-party spoiler candidate, and the America First vote was sort of split between Tina Peters and Mike O'Donnell, and then the establishment GOP. So these were low margins, right? But Pam Anderson ended up winning. That is the intention of Mike O'Donnell, in my opinion. It was why he was there to begin with. This is Draza Smith's work on third-party spoiler candidates, but that that was contrived, and I don't believe that we can say more people voted for Pam Anderson because here in Colorado elections are a black box, and if you ask questions, you end up in prison. So
we'll get into the El Paso County because me and Ash both did a lot of work on the primary in El Paso County, but yeah, we'll land that plane there.
So we'll do this. Obviously, folks, this will bring us to the
the grueling end.
Put up your tray tables, bring your seats up right, fasten your seatbelts. We're going to come in for a landing. We're going to show a post that Ash and Ken brought to my attention with Tina But before we get that, this will be the end of part 1 in a 3-part series. If you guys want more information of this, if you guys want some very detailed parts of what was covered tonight, you got to go watch Why We Vote with Ash and Brian over there at Badlands Media on Rumble. So make sure you're going there. Those links will be down in the description for you guys. And then I'll let you guys let people know where you can follow each other. So let me bring this up on the screen first. Did one of you guys want to read this?
Yeah,
I can. Oh, go ahead, Brian.
A message from Tina Peters on her son's birthday. Today is the second year in a row that I've been in prison for the birthday of my precious Navy SEAL Remington. This day is never easy for me. All I can think of is his beautiful smile, his courageous spirit that made him the leader that he was, and the sacrifice that he and so many others made to preserve this great nation and the rights that we all hold sacred. I will never forget when I learned of his passing. I thought back to conversations that we had, like the day I told him I was thinking of running for office. Of all the things I had done in my life, he was my pride and joy, my son, my seal, and my heart. When I asked God not to take me until I had finished what I came here to do, I knew that I could face that day peacefully I knew I could face that day peacefully when it came, because I would be able to see my beautiful Remington again. The sacrifice that everyone in uniform makes to protect what so many take for granted dwarfs the 13 months that I've been in prison for upholding my duty. And I hope that the American people realize how precious the freedom that we still have truly is. The past year in prison has reminded me of how much we have to lose if we let the corruption that has been taken hold in our country win, and how quickly our freedom can be taken away from us at the hands of those who would bow to the temptation of power, money, or fear. Even after 13 months in prison, I've not given up. I believe in this country, in the Constitution, and in the American people. To everyone listening, remember that the truth matters. The truth is why I'm here in prison today. The truth is the reason so many gave their lives so that we may enjoy as a nation as great as this one, and is the reason why every one of us must continue to fight so what has been done to me will never happen again. My case is one of many examples of how the power of a captured government can be turned against the people. What they have done to me will become precedent that can be used against every other American, just as the attacks on our great president of the United States, Donald Trump, will be remembered for generations to come as the embodiment of evil gone unchecked. The only judgment that matters in the end is not at the hands of a judge, but that of God seeing over the choices we make until our last moment, to stand or be silent, to bow or to persevere. Thank you to everyone who has supported me, and every one of you who continues as I step forward in this fight day by day. I have a long road ahead, but the fight that America will endure in the coming years will test every one of us. I pray that justice is seen and heard, that our nation continues to stand tall, and that the American people never forgets the treasure that we have in a free country. If you can support my fight, I am forever grateful. If you pray for me, know that I am praying for all of you. I miss my Remington every day. Please keep fighting so that you never have to miss this great country the way that I miss my son. Fight, fight, fight. Tina Peters.
And if you'd like to support Tina Peters, tinapeters.us is the only place to donate, is my understanding. There are other efforts out there, but tinapeters.us is where you can support her. And she's, involved in multiple appeals. We've covered them on Why We Vote. And I did, have gone in and live tweeted some of those hearings when I've been available to do so. It's current right now that she is so Brian mentioned that she had an appeal and it was denied. And part of why it was denied, the stated position of the court, is at a fear of what she might say. And that is a First Amendment violation. So that has been appealed to federal court to intervene for Tina Peters. And that's being heard now. We expect an answer on it any day. They're only looking at the First Amendment aspect of it. Is is she being held because of her protected speech and whatnot? It's bizarro world that an elected official gets 9 years for one misrepresentation. And again, the felonies on impersonation and identity theft, those were acquitted. They were heard. The jury decided there was reasonable doubt there. So I think in that respect, the process worked. But the only reason that happened is because they got it in on impeachment evidence. Because they did not have to, disclose to the prosecution. The prosecution would have, I think, been effective in getting that removed and not allow the jury to see it if they had done it any other way than impeaching Jerry Wood. And so, it's a violation of everything we hold dear in terms of our rights and against persecution. We'll bring you the answer to her First Amendment appeal in federal court when it comes down.
There you guys have it. On the bottom of the screen, you've seen it scrolling. The links to follow Ash, the links to follow Brian, the links to support Tina. Again, those will also be down in the description over there on Rumble. If you're watching on a different platform, make sure you go over to Rumble. Go check that description box so you know how to find all these people. Ash, Brian, real quick, where can people find you for those that are listening and not watching and haven't seen the scroll bar?
All of my stuff is at linktree.com/Ash in America. Show schedule, writing places. I'm sort of all over the place. And Ash in America on X is my #1 social.
Yeah, you can follow me on YouTube at CanCon Actual. I just got my YouTube channel back. Rumble at CanCon. I write for the Gateway Pundit under Brian Lupo. And you can find me at Badlands Media just about every day as well as my other 2 co-hosts here.
There you have it. As a matter of fact, you guys need to stick around because immediately following this show right now in a few minutes is DEFCON 0 with me and my brother Josh. It's going to be a fire show tonight with all the stuff that's been happening in the last week. So with that, you guys, God bless. Semper Fi. First in, last out. I'll catch you on the next one.